Good morning. Good morning, members of the Mental Health Vulnerable Adult Task Force and members of the public who may be joining us online or who are here present. We'd like to welcome you to our second meeting of this task force today. Mr. Chairman, just a little outline as we get ready and before we go into roll call. There will be some of these sections that we skip through a little bit faster than others because of the work that we've done on our last session. We'll just kind of be reviewing those, particularly diversion, where we've got a pilot program that's being developed up in Campbell County. Just going to be talking a little bit about the CIT training and maybe what we can do for that this morning, but that'll be about all we do there. And then we'll be spending quite a bit of time this afternoon on K-12 mental health services and the work that subcommittee's done. So with that, Katie, let's go ahead and call the roll.
Good morning, Mr. Chairman. Roll call for the Mental Health and Vulnerable Adult Task Force for August 9th, 2023. Senator Barlow. Here. Senator Nethercott. Here. Representative Summers. Here. Representative Zwanitzer. Here. Director Johansson. Here. Director Schmidt. Here. Deputy Director Babbitt. Here. Dr. Ballard.
Excused, sorry.
Ms. Butler. Here. Co-Chairman Baldwin.
Here.
Co-Chairman Larson.
Here. Yeah. So we expect Laura will be back as soon as she gets done presenting down in education this morning. Mr. Chairman, any comments you'd like to make before we start?
None, Mr. Chairman. I think we're ready to go.
Just, again, it's just a matter of information for those who may be watching online. This task force is made up a little differently than a select committee or a standing committee, where those committees are made up exclusively of members serving in the legislature. A task force can be made up of members of the legislature and others. We have representatives from the judicial branch, from the Department of Education, Department of Corrections with Mrs. Babbitt and Mrs. Butler here from the judicial branch. We've got Director Johansson from the Department of Health and Director Schmidt from the Department of Family Services. And so that makes this a little bit unique, but it also is why we can't sponsor a bill as a committee. Any bills that we work through this task force, we then will recommend to be presented at a standing committee that we will refer them to. So with that in mind, we'd like to start this morning on the diversion. And members of the task force, my thoughts on this conversation on CIT, crisis intervention teams, is as we contemplate what we can do and what we could recommend back to the legislature. We've heard how critical CIT training is, and we've talked about, is it possible to have it at post the peace officer training as part of their component. We know that we have CIT training taking place with, particularly we up in the Bighorn Basin in Powell. That Sheriff's Department has been actively involved. We have about 15 to 17% of our law enforcement that is CIT trained. I think that from the comments we received that it would be nice if we could see that percentage increase. And so in the back of my mind, I'm wondering if there's some way that we could, as you look at the structure of CIT training, maybe we make that funding available in the county so that they can get a train the trainer done so that they can have ongoing CIT training and not have to go to post. That may or may not work. So that's part of this conversation. We'd kind of like to have you keep that in the back of your mind and see if that's a worthy consideration to move forward. So we've got Alan Thompson with us this morning, who's the executive director of WASCOP, and then we also have Chris Walsh, who is with us online this morning, who is the director, the training facility in Douglas. We're going to ask if we can get Mr. Waltz. Oh, he's up. If we could get Mr. Waltz introduced. I know he's got some other commitments. Mr. Waltz, appreciate your time, appreciate the information that you submitted, and that's been very helpful. So if you could kind of walk us through the training perspective on CIT and maybe give us some recommendations or your thoughts.
Thank you, Mr. Chairman. I would be happy to. And my role is basically validating and ensuring that everybody maintains certifications in the state. My office is at the Academy. Director Bain with the Academy actually handles basic training and instruction here, but we work very closely together.
Mr. Waltz,
Yes.
Mr. Waltz, could we just ask you to get a little friendlier with your microphone? You're pretty soft.
I will speak up louder. I hope I'm coming through some. I'm not sure how to adjust it.
That's
Are
better.
you able to? Is
There
that
you
better?
Thank you.
What people commonly refer to as CIT is Crisis Intervention Team. And that training involves, it's very intensive with each community and the resources, the mental health resources that they have in each community. So there's general aspects of the training, and that can be taught in a classroom. It can be taught and validated through practical skills and exercises that could be incorporated in the Academy, and it is incorporated in the Academy. But the major crux of it is what those individual communities that we have available to their residents, and those are all very unique. So Casper and Cheyenne, of course, are going to have a great deal of resources where Newcastle and Lusk are not going to. So they all need to partner up and create that unique kind of bond between their mental health professionals, their officers, and their advocates. And their advocates would be the typically volunteer groups that trying to improve the mental health availability of services to people in their community. I did provide a breakdown on some related topics that are taught in basic training and the advanced training of the CIT team concept. So the full model at the Academy would be very difficult because think of the diversity of all the different communities we have and what they may have available. And it would be virtually impossible to teach each of those community specific options in a general basic setting. The CIT training is absolutely fantastic. I think that it's the availability of funds that has been provided that WASCOP is managing for different agencies to put on CIT is a fantastic step. And maybe I suspect you probably have more questions than me just giving you an overview. So, Mr. Chair, I would stand to clarify anything that anybody would have questions on.
Thank you, Chris. Members of the committee, any questions for Mr. Walsh? Senator Barlow.
Thank you, Mr. Chairman. Mr. Walls, thank you for your information. So there's two things I'm going to question. On page 2 of the document, it says WLI would not be able to include advocacy groups and mental health resources into a basic program. I guess from what I understood in your testimony, that's because of the uniqueness of each community's resources, or is that some other prohibition that you would see? So maybe answer that question would be appreciated. Thank you.
Mr. Walsh.
Thank you, Mr. Chair. Mr. Barlow, it is because of the uniqueness of what's available in each community. So I'll just use Casper as a reference. We have, the Central Wyoming Counseling Center. We have the Wyoming Behavioral Institute, and a lot of volunteer organizations. When you put on a CIT class in Natrona County, it actually includes all of those people, and the officers and the actual caregivers or providers work together and go through scenarios and develop those partnerships. Where as a smaller community wouldn't have those options. They would have a different set of options. But it's that individual piece that makes each community unique that also makes it difficult to provide general training at the academy. Does that answer your question, sir?
Yes, thank you. I just wanted to clarify that from your earlier statement. The second question I'd have is in the chart on page 3 of the submission, there's an asterisk and it has mental health first aid. How many hours or what's the basis of that course? It looks like it's going to become available in 2024. Thank you.
Mr. Walsh?
Mr. Chairman, Mr. Barlow, that class, the Academy has evaluated over the past year. It will be, it's primarily designed for people in a suicidal state, and it's going to be approximately 8 hours long. They're still finalizing exactly what it's going to look like for the 2024 upcoming year. I would also add that Director Bain has commissioned a job task analysis for peace officer training that will adjust the 2024 schedule as well. And so we may see more aspects in it, but right now the mental health first aid will become a part of that curriculum.
Any other questions? Chris, thank you. Appreciate you getting us that information and helping us understand what you can do there.
My pleasure, Mr. Chairman. And if there's anything else I can offer, please don't hesitate to ask.
Thank you. Mr. Thompson, you're with us. Appreciate the information you provided. And could you kind of give us an update on peace officers and in WASCOPS, your thoughts on this?
Thank you, Mr. Chairman. Does everybody hear me all right?
We can.
Thank you very much. My name is Alan Thompson. I'm the Executive Director of WASCOP. I appreciate this opportunity, Mr. Chairman. There's been a lot of robust discussions across the state and in various law enforcement circles about CIT and especially this mental health first aid. So there's kind of a lot of information here that we're working on, but I think Director Walsh summarized this pretty succinctly for you. I would just like to add that mental health first aid component, that's an evidence-based 5-step action plan with the goal to get individuals in crisis connected with the appropriate resource. So it's along those same lines of CIT, and whether or not you have a CIT in your community, mental health first aid is going to help law enforcement get the skills and the training that they need to help those people in crisis. We would learn in that 8-hour class how to identify the risk factors and warning signs of mental health issues and understand the importance of early intervention, and just learn how to help get those people in crisis to the right resource. It's very, it's a very good thing that the Academy is researching how they can implement that into the basic courses in Douglas, but then that leaves the law enforcement professionals across the state needing that training, in the years to come. And we are working at WASCOP right now to offer that mental health first aid through grants that we have existing right now across the state. We've just got trainers up and running. They're finishing their final component of that Train the Trainer program through the month of August, and we should be able to offer those courses across the state as early as September 1. And I do want to kind of reiterate the CIT versus mental health versus de-escalation training that Director Walsh had mentioned. I think from my understanding of this task force and the meetings that you've had in May and June today, your hope is to provide law enforcement with the resources to work with those going through mental health crisis. And I think a conglomeration of all of these things, a CIT program that's robust and working well within the communities across the state, and a mental health first aid component, or other de-escalation trainings that are out there to help our law enforcement professionals, meet the needs of those in crisis. And that's I guess just a quick summary, Mr. Chairman. I'd stand for any questions that you might have.
Thank you, Mr. Thompson. Questions, committee? Senator Barlow?
Thank you, Mr. Chairman. Congratulations again on your new position as Executive Director. Mr. Thompson. So my question is, one of the documents that we received from Mr. Walsh talks about 20 to 25% recommendation of CIT training. So based on what the grants that you're putting out, so I'll have two questions. What kind of goals are you setting, or are you kind of looking at when you award grants for different agencies that come forward to, I mean, obviously somebody has to apply to be considered. So what kind of saturation level, I guess maybe a term to be used, are we trying to accomplish? And two, what's the source of the grants that you're utilizing to accomplish this? Thank you, Mr. Chairman.
Mr. Thompson?
Yeah, Mr. Chairman, the goal of the CIT grant that we have is to provide that training and reimbursement to the agencies across the state to the level of the Memphis program that we use, which is, that 20 to 25%. So we are working towards that. We have kind of a deadline approaching mid next year with that grant. It's sourced through the Wyoming Department of Health, and that will expire next year. We are currently having conversations on how to utilize that existing grant to better formulate a statewide organization, a consortium of sorts, to help with that education and implementation of CIT across the state. We are getting there. One of the biggest struggles that we have is the overall workforce shortages in law enforcement. A 40-hour training is a huge commitment for law enforcement to send their personnel through. And we can throw as much money as we have at that, but it still doesn't change the fact we need people working the street, and we can't send an entire agency to CIT training. So our biggest struggle is the workforce shortages and the requirements of other trainings that are needed, based on statute or policy. That's our goal with it. And Mr. Chairman, there was a second part to that question.
Senator Barlow?
Thank you, Mr. Chairman. So I think you covered it with the funding source. You also mentioned in your previous testimony about the mental health first aid. Is that some of the adjustment you're trying to make with the Department of Health, is to utilize some of these funds for mental health first aid instead of the CIT, just due to the, and then what is when the Director Walsh talked about it, Executive Director Walsh talked about it, was 8 hours. There's a pretty significant difference in 8 hours versus 40 hours, those two training types. So am I accurate in saying some of your adjustment to meet that grant deadline is to move some resources toward the mental health first aid? Thank you, Mr. Chairman.
Mr. Thompson?
Mr. Chairman, there are two grant sources out there that we're using to accomplish both of them. Our feeling at WASCOP is that just like other facets of law enforcement, you have people that are very astute at investigations and people that are very good at that call-to-call crisis intervention. Some are really good at traffic. I think I would say that not every officer is cut out to be a CIT officer or deputy. So the mental health first aid covers that minimum training that you would need to interact with people in crisis that arguably every officer should have, which is a great concept for the academy to take on. But CIT is that community network approach that we expect those officers or deputies to be involved in, that team approach and part of the conversation and part of the ongoing meetings in the county, not just a 40-hour training. So there's the difference there. And there are two different funding streams that we have right now through grants from the Department of Health that are paying for those two things.
Questions? So, Mr. Thompson, I have a couple of questions just on the structure of the grant and how you're functioning now versus the problems that you've kind of identified, which is taking these people away from their job for a week or for whatever to attend this training. So with this grant that you currently have, tell me how you're providing the CIT training. How many people where do they go and how's that working?
Yeah, Mr. Chairman, we have funding available to reimburse agencies for the time that it would take to send their officer to this class and backfill that position, presumably with overtime, any of the travel costs associated with it and so forth. There's some funding in that grant available for any costs associated with putting on the training. We've been working well across the state with our prevention partners, and a lot of times grant funding through their channels can pay for the actual training component. Much of the actual CIT delivery within the community isn't actually a huge cost to either our grant funds or our prevention grant funds, because the individual instructors in there are community partners that are volunteering their time to come in and teach an hour block or a 2-hour block. Or we have a coordinator that might be contracted with the prevention or the county that's putting it on to help with the role-playing portions of that and so forth. So what we're looking at specifically with that grant is the operational costs that we haven't needed to date, trying to use that operational cost section of it to ramp up the robustness, contract with a vendor of sorts that can coordinate those trainings across the state. And it just depends on the community and their ability to do this. I think that's kind of where we've slowed down throughout this year. And we're seeing the availability of those CIT. We have one coming up in Lincoln County that hasn't hosted one in the past, to my knowledge. And we're looking at working within the parameters of these grants to kind of have this consortium of sorts that helps get the message out, provide resources, provide funding, provide coordinators, and that sort of thing.
So I think we're getting closer, but I'm still not understanding well, because as I read through the information on CIT, you do have a coordinator. I mean, CIT is a licensed program and under the Memphis model. And so there's some certification that's required before you can put it on. As I read it, it doesn't imply that you can just randomly use local resources if they're not certified to make the presentation. Do I understand that correctly?
Mr. Chairman, the CIT model certifies a coordinator, and that coordinator then chooses the people to be the presenters in that course. So there's not an individual certification for each of the presenters. They're just determined based on their subject matter expertise. So in my experience with the courses that we've offered in Sheridan, I've personally taught a couple of the blocks based on my law enforcement experience with topics like excited delirium and suicide. Whereas we have providers coming from, in our community, we have the VA Medical Center, we had the Northern Wyoming Mental Health, which is now part of the Volunteers of America organization. So those two entities, Shared Memorial Hospital, all of those entities that are involved in that team approach will provide subject matter experts that aren't necessarily certified by or coordinators of CIT. They just have a subject matter expertise, and oftentimes they'll volunteer their time for that.
I see that explanation conflicting a little bit with what I'm reading here on the train the trainer and stuff, but nonetheless, I get your drift. And so then the point is you're better to do the CIT course in the location where the law enforcement officers reside rather than sending them to the hinterlands to receive that training. Am I accurate there?
Yes, Mr. Chairman, or at least regionally. So maybe a tri-county area where a small neighboring county would rely on the resources of a bigger neighboring county. So yes, in the area where they work, or the region where they work.
So that helps me. And so then my question is because law enforcement personnel are fluid, they come and go just like any other profession, it seems reasonable that you'd want to have established resources in the region, in the community, or however that looks, so that you could be providing that CIT training on an ongoing basis. Is that an appropriate assumption on my part?
Yes, Mr. Chairman, I think that's a great assumption that regardless of what's offered on the basic level or our goal of a certain percentage of CIT trained officers, that is always going to be fluid. And there are, individuals that come from other states that don't attend our full academy in Wyoming. So how we make sure that each of our officers have at least the minimum of crisis de-escalation training and that enrollment or involvement in CIT on the local level will, for my career and most officers' career out there, will be an ongoing process for years to come.
So then the question probably that I should ask is, what do we need to have located around the state? What level is it? Is it the coordinator? Is it the trainer? What should we have established so that they can provide that ongoing training with the resources available in the community?
Yes, Mr. Chairman, if we can reach our goal of having a statewide network of CIT while not having oversight or control on the local level, they can be a resource for, I think that will then help us identify the needs of those, the areas, and then what specific type of training would be needed, whether it be just a coordinator or a train the trainer, or what CIT looks like in Northeast Wyoming versus Southwest Wyoming, and understanding that. I mean, I have a general idea looking at it from my experience now, but until we actually have those conversations with each of the counties and figuring out what region they would like to work under, what resources are available in their region, I don't think we're quite there yet with a solid answer for you, Mr. Chairman.
So I guess maybe we could make a request of you to maybe look at that, because I think as we've looked at this diversion model and we look at the mental health issues, this CIT training seems to be an important component of that. And so trying to be a little proactive as we implement this diversion process to make sure that we have the CIT training in place when that gets ready to move forward statewide. It would be helpful if we could kind of understand what your thoughts and recommendations are. We've got another meeting coming up. If you think it's possible, could you accept the challenge in trying to give us an idea of what it would take to make sure that that structure's in place, so that we can determine if that's something that we could move forward either through funding or legislation or whatever? While we're just trying to put that in place. And then my last question is, as we talk about this mental health first aid, is that absent in the CIT training? So meaning, if it's in the CIT training and CIT is not perhaps for everyone, but at least that component of CIT training could be given to everyone. Help me understand that.
Yes, Mr. Chairman, I would say that component is in the CIT training, but we wouldn't be offering CIT training if we taught just that component of it. We would actually be teaching more of a mental health first aid, which is already a certified program that we can already go through. So there's a lot of what I believe to be similarities in there. And the mental health first aid is the practitioner process, and the CIT would be more of the administrator process. So while the individuals involved in CIT and trained in CIT aren't necessarily administering the program locally, they're going to be more heavily involved in the community conversation going forward on what the needs of that community are. I do think that they're both great programs, and I think if we're going to look at a CIT community, that mental health first aid is a component of that CIT community.
And so is that kind of in the same state or status currently as the CIT training? We're trying to figure out how we should approach that statewide, Or is that in place? Meaning
Yes.
the mental health first aid?
Yeah, Mr. Chairman, we are, have just, or are about to have the trainers certified across the state, and they were chosen to be regionally available. And then now that they're going to be in place soon, then we offer up the ability to have those classes locally. That's going to be driven by the availability of the local agencies. And then, once they have that availability to send 5 or 10 people to this class, we put on a class in the area, and then we start, working across the state to have that certification go to each of the 4 corners of the state. We're close to that, and it is going to be an ongoing process like CIT.
Thank you. Chairman Baldwin.
Thank you, Mr. Chairman. Just a quick question, if you would, Mr. Thompson. We've talked a lot about regions, maybe a minor question, but what are the regions that you're identifying? I know we talk about regions in EMS, we talk about trauma regions. What are your regions, and what exactly are you showing us here?
Mr. Chairman and Task Force, that is a very good question, because I think that's going to be dictated on the homework that I've gotten today. I think you would look at an area of maybe Northeast Wyoming, where you have Crick County, Weston County, Niobrara County, that are smaller populations. Crick County might want to be in a group or a region with Campbell County because of the resources that they have nearby. It just depends on the population base, the resources that they have, and probably more importantly, what resources they're already using. There's a lot of cross-county line resources when it comes to mental health and Title 25. What are they already doing, and what would make sense going forward for forming that? And I think, that would be best answered if we can get that statewide consortium of sorts to get together and discuss the existing programs that we have and what makes sense. So maybe a 1-county region in Natrona County, and maybe a 4-county region in the Bighorn Basin. I don't have the answer to that today, but that's our hope in the near future, is to understand what those regions mean.
Thank you. Any other questions? Mr. Thompson, thank you. That helps us a lot. We look forward to seeing what your recommendations are at our next meeting, if that's possible.
Thank you, Mr. Chairman.
Okay, any public comment on the diversion section? Seeing none, we'll move into the vulnerable adult section. And members, you'll recall that last time we, in the vulnerable adult, we looked at the 2017 task force and recommendations that they made on some statutory changes. We moved some of those. I would share with you that those that we moved on cross-reporting between DFS and law enforcement, and the length of time that emergency placements can be in place. We had a meeting with the chairman of Joint Judiciary. We'll present these to them in September. They've got a pretty full plate. They'll determine at that meeting whether they'll move them forward. If they don't, we might come back and impose upon the good chairman of appropriations or somebody else to help us move those forward. So with that in mind, we did delay the conversation on civil cause of action. We made a couple of changes in that bill, you'll recall, and also we delayed the discussion on vulnerable adult. And so Senator Barlow or Senator Nethercott, I would defer to you, I guess, Senator Barlow, on who you would like to have present these bills and where you think we're at on them today, and let's have those.
Thank you, Mr. Chairman. So to be clear, based on the action we took at our last meeting, we made some modest adjustments. I'll start with this LSO 0017, which is civil cause of action, version 0.6. We made a couple adjustments to that. And then, of course, staff has also added, or not added, but maybe has some additional language. I'm looking at some of the verbiage that has been, I guess, we need to keep in mind. So I don't have anything more to add. Our group has not met since our last meeting to work through any changes so Chairman Nethercott has more would offer more, I'm sure, because this is something that's certainly within her realm of expertise. Thank you.
Senator Nethercott, any thoughts?
Mr. Chairman, I do. I can certainly go over the bill, or we can, if I recall from our last meeting, I had asked LSO to provide some of these additional staff comments that we find throughout the bill. So perhaps it would be appropriate to have LSO come forward and explain some of those staff comments. I know I have some questions about those, and identify where we go from here.
Thank you. So Anna, you're on, and we've said do it from where you're at. That'll be fine. Just be friendly with the mic and kind of walk us through your staff comments. And would you remind us, it seems like we've done away with some language. We're talking about financial exploitation. We deleted that, was really the main thing that we've done. And then we asked you for these comments. So could you just bring us up to speed on what you found on malicious and some of the other comments that you've got there?
Yes, Mr. Chairman. So, yes, as you said, the mentions of financial exploitation were taken out of the bill draft. And also the allowance of the court awarding reasonable attorney fees was added in. And then on page 2, there is a staff comment. I looked at the Uniform Power of Attorney Act at the task force's request to try to find other people who could act on behalf of a vulnerable adult in a civil cause of action. And an agent for the person, for the vulnerable adult might be able to act, it might be able to bring a civil cause of action on behalf of the vulnerable adult. And then I also looked at some other state statutes regarding civil cause of action. And notably, one state allows the guardian ad litem to bring a civil cause of action on behalf of a vulnerable adult, so that's something to consider as well. And then there was also several mentions of the word, or uses of the word malicious throughout statute. I think the most interesting one is on page 4, under 23.3405. If the trier of fact finds that the unlawful conduct was malicious, it may award punitive damages to the injured party, which is basically what we're doing in the civil cause of action bill draft that you have before you. And with that, I would stand for any questions.
Senator Nethercott.
Thank you, Mr. Chairman. There's a lot of work to do in our statutes. Just as a side note for the lawyers in the room, the statute that Anna pointed out is regarding what is a criminal penalty. And so the trier of fact would be a criminal jury that would be awarding punitive damages to an injured party, the unlawful taking of wildlife. Yeah. Perhaps that's to the landowner, I don't know. Kind of an unusual piece there. A couple of questions for Anna, if I may, Mr. Chairman.
Please.
And were we able to find a definition of malicious anywhere in statute other than it being referenced or found in a jury instruction? The civil pattern jury instructions?
Mr. Chairman, Senator Nethercott, I did not find a definition of malicious in statute.
And then another just piece here. So in the definitions, moving back to page 2, on the question of who can bring this cause of action on behalf of the vulnerable adult, in addition to the vulnerable adult themselves, which is somewhat unique because you're assuming that the vulnerable adult probably has competency issues. And so can the vulnerable adult actually ever do that? Interesting question, but not for us to necessarily decide today. And so we have listing here that on line 7, page 2, that a person's guardian, conservator, or the personal representative of the estate of the deceased vulnerable adult. Those are the 3 different type of legal statuses that can bring this cause of action. As this committee knows, the guardian or the conservator is a court-appointed guardian or conservator is what that means there. A personal representative of the estate would be, and as indicated here in the statute, of a deceased vulnerable adult. I'm curious, when this language was drafted for Anna, if there's any other civil circumstances where the civil cause of action survives the death of the injured party, of the vulnerable adult in this case. there's survivor's action in wrongful death type cases, but when you don't kill the individual involved, is there any, is this unusual? Because I think it might be.
Anna?
Mr. Chairman, Senator Nethercott, I will tell you that I haven't found any other instances in statute where that's possible, but other states, there have been other states that use similar language in their civil cause of action statutes to this.
You know, I would ask, Mr. Chairman, if we can, is to have Anna do maybe a short little memo on that piece. I do anticipate that being a problem if this bill moves forward and passes and comes into law, or just something that we can provide clarity on at this time, rather than the decedent's family having to do it in litigation. And then thirdly, Mr. Chairman, if I can.
So can I ask a question on that before you move? So is the conversation or the question that you bring up, is it that's unique that then the estate of the vulnerable adult after the death can then come back and ask for compensation? And does that depend upon what the wrong was, or am I kind of getting to the meat of the issue?
Typically, Mr. Chairman, if I can, torts sometimes don't survive the death of the decedent. Some do. Some civil wrongs don't survive the death of the decedent, in the same way that criminal wrongs don't necessarily survive. So that's how that looks, because the person's not available to testify, right? And so they don't move forward with charges. They can, particularly if it's a homicide, but oftentimes those simply don't move forward. So I do think that we can provide some additional clarity here. That is actually what we intend to do, is to have it be a type of survivor's action, and maybe circle back to our other statutes on a survivor's action here, instead of it kind of being implied in the statute that a personal representative of the estate can bring it. I think might be some clarity.
Does it seem somewhat, in my thinking, you could just really seem appropriate depending on the circumstance of the adult, their circumstances at the time they become vulnerable and at the time of their passing. If they had a large estate and they were wronged financially through exploitation or something, that the heirs to that estate now would want to have the ability to pursue. Am I seeing that accurate?
You could be. I just want to bring to your attention that we have, I think, eliminated the distinction of financial exploitation, and it's any exploitation.
Right, but which would include financial.
It could.
Yeah, or any type of exploitation, but there could be that impact from the wrongs to the vulnerable adult, or it could be on the other side of the spectrum where you have a very indigent type of individual where there really are no assets and the wrong, and so you would, I think, typically there probably wouldn't be any. I don't know, but just for my point, I'm just trying to see if I'm understanding that accurately.
Yes, I think the statute, as we've adopted it, likely from other states, contemplated the ability of heirs to go back and obtain monies unlawfully received by the person who exploited the vulnerable adult. It's likely what it's contemplating. However, it's broader than that, and I'm just trying to get it right the first time.
Sure. So are you of the opinion that would you like, before we do our final work of this bill, would you like to get that memo? Do you want to move, so you'd like to wait in on this again?
Mr. Chairman,
Fine.
Mr. Chairman, no, I'll just go ahead and take the lead on that and make sure we get it right when it goes to judiciary.
Okay.
And we'll let judiciary staff maybe address that issue.
Okay. So are you comfortable then with working the bill the way we?
I am. I have one more question I have,
Okay.
and one more consideration of this committee, if I may, Mr.
Please.
Chairman. So on this topic of who may bring the action, and I had referenced the Uniform Power of Attorney Act in our last meeting of who can bring forward the action, and Anna has provided for us the definition of agent, which is the the person who possesses the power of attorney, which is not included here, and so it's something we may want to consider adding, which is the agent. But what really I was looking at from the power of attorney statute is found in statute, I think, who can bring cause of action against the agent, and that's found in 39116. And so in 39116, we've identified the following people who can bring a cause of action to evaluate the conduct of an agent when suspected exploitation is occurring. And that's the principal of the agent, so the power of attorney can, guardian or conservator, or other fiduciary acting for the principal. A person authorized to make healthcare decisions, so that would be an agent for healthcare purposes, which is different than just a general durable power of attorney. The principal's spouse, parent, or descendant. So this kind of goes to that issue of heirs. And then it specifically talks about a person who would qualify as a presumptive heir. The principal's caregiver or another person that demonstrates sufficient interest in the principal's welfare. A person named as a beneficiary. So there's a huge list of individuals that can bring an action against an agent out of concern for the welfare of a vulnerable adult, assuming it's a vulnerable adult.
Against the agent.
Correct. But the agent's being suspected of exploiting the vulnerable adult, which is why the action's coming forward.
Agent is a guardian or conservator?
The agent is typically a power of attorney. That's why this is found in the Uniform Power of Attorney Act. Maybe this is a topic I'll bring to the judiciary too.
Well, I think we ought to get it as refined as we can. We have your expertise here, but my question then is up there on page 2, where on line 6 and line 7, the action may be brought by the vulnerable adult, and then would you change that to say, or his agent as defined in 39102?
Well, that's a technical solution. Now we have to make the policy decision and then of whether or not we want all of those people to be able to do that and have standing to do that. So it probably is easier to have that listing in front of us at that time. So it may be something that the Judiciary Committee certainly can evaluate list by list with further review at that time, or we can kind of look at it now, or I can repeat the list.
It's my opinion, Chairman Nethercott, after talking to the Chairman of Judiciary, that it's going to be pretty tough for them to spend a lot of time. And so I think the 16 or 17 bills that they are trying to incubate.
As they should.
As they should, and I think that they, yes, and I think they would appreciate any nesting that we could do as well. So, representatives want to.
And I brought this up at the last meeting, Mr. Chairman, but ultimately, I don't care if it's one other person or if we can just say that statute, but if the agent solves with the guardian or the conservator, and that's the person who's causing the egregious action, right? The vulnerable adult's not going to be able to bring it if they're not cognizant. And obviously, if it's against their own conservator, you need some third party, and I don't know, a medical professional would actually do that. Whether it's the guardian ad litem, like another state, but I would like there to be at least one other person, should it be, the conservator, guardian, and agent are all the same person, and they're the one causing the issue. You need someone outside of that to be able to bring that, to have standing. And so I guess I'm asking Senator Nethercott, who would the best person be if there are no children? Who's the best person to put in the situation? I don't think it's the medical caregiver, because they're not going to understand the financials. There's got to be some other third party, a court, a GAL, who could bring an action.
Senator Nethercott.
Well, it's very fact dependent on the vulnerable adult, but
I've seen the fluctuation of the lips like old things.
the listing found in the Uniform Power of Attorney Act is from a uniform act that's been passed in most states, as identified as people, individuals around a vulnerable adult that should have the standing to make an inquiry to the court concerning the actions of an agent that's supposed to be legally acting on the vulnerable adult's behalf and has a fiduciary relationship.
So on line 7, could we just say after person's guardian or conservator, comma, any applicable person found in the Uniform Act, and cite that chapter, title, and article, or personal representative? Is that the easiest to do? And just reference that any of those people bring a cause of action?
Yes.
I'd like to do that then, Mr. Chairman.
So bear that in mind as we're not quite working the bill yet. We're just going to those. We'll have Senator Nethercott help us work the bill when she's ready.
Anna, there's a recent Supreme Court opinion about whether or not an incompetent adult can be divorced. We need to look at that opinion.
I can, Mr. Chairman, Senator Nethercott, I can find that.
Great. So, that's it, Mr. Chairman. I just wanted to bring those additional people who could bring a cause of action in this case on behalf of the vulnerable adult to the committee's attention. And that's it. I'm happy to answer any further questions or explain the bill or turn it over back to you.
So what I'd like to ask you to do now is to just go ahead as a chairman and walk us through this bill, and let's work it and see if there's any amendments, and we'll just turn that over to you, and then we'll, Senator Barlow.
Thank you, Mr. Chairman. Before you do that, I'm interested if we add some language to this particular sentence. The sentence is already long and it gets a little bit longer. And the component that Senator Nethercott brought in earlier about the estate component, I'm wondering if that actually should be divided out into a separate sentence, and maybe we actually, in that case, designate financially, a financial component. Because we look at the full definition of exploit, there's a lot of other things that post someone's passing don't make as much sense to pursue, but the financial may be something that would be something to continue to pursue or leave that door open. So anyway, I don't know all I'm saying is if we're going to be messing in this sentence and we have a question about that, maybe we segregate that out and then have a discussion about that separately. If there's a way to actually delineate or be more precise about what that deceased vulnerable adult, they could be pursuing that. If it's just because of financial, because this also, as you recall from above, has punitive damages. Punitive damage doesn't seem to make sense if someone has passed, but getting their principal, whatever money was lost, that does make sense. So anyway, I think maybe there's a way to divide this a little bit. Obviously, I'll defer to the good Chairman Nethercott. Thank you, Mr. Chairman.
Ms. Butler.
Mr. Chairman, I just wanted to add a couple of things. On the causes of action that survive, there is a statute that defines that. It's 14101. And so that includes causes of action for mezzanine profits, injuries to the person, an injury to real or personal estate, or any deceit or fraud. So this could potentially fall within that. If we want to specify, we could, but I think if it's an injury to the person or an injury to the, to the personal estate of someone, it could potentially fall within that statute. And the second thing is, to Senator Nethercott's point, the Joint Judiciary, I think has a bill draft, or will have a bill draft at their meeting in September about that Supreme Court case. So there could be some movement there. I haven't seen the bill draft, but that was my understanding at the April meeting, I believe, is that they were going to create a bill draft based on the finding in that case. So.
Great. Look forward to looking at that.
Great.
Thank you.
Okay. Any other thoughts, Senator Barlow?
I do have a couple of questions on malicious still. So if you're exploiting the finances of the vulnerable adult, but you don't mean to cause them physical harm, I'm just trying to think how do you extra prove malicious intent that you're trying to impede their death? I mean, is that a common legal, judicial, easy to add that extra on? I worry about having a separate thing that you have to achieve in a courtroom to say, now I can seek punitive damages.
Mr. Chairman?
Please.
Anna, do you have access to the civil pattern jury instructions?
I can pull them up real quick.
You can just say yes. Public.
I don't know. I don't know if they're in there, they're defined in there. Or if there's case law defining malicious.
So it sounds like we're absent a definition of malicious, but
Maybe.
maybe, but isn't it the intent that malicious is not being in the best interest of the person?
No,
It's not?
no.
Every crime malicious.
How would you categorize it?
Yeah, there's an intent involved associated with malicious. It's not just you didn't act in their best interest, whether you were being reckless or negligent. So you just weren't doing your job and taking care of them because you were busy somewhere else. You weren't intending to harm them, but you were negligent, which actually caused them harm, but there wasn't an intent to harm. So the malicious has to have some type of mental thought associated with intending to be malicious, intending to harm.
Mr. Chairman, Senator Nethercott, I do have those pulled up.
Go ahead, Anna.
Do you want me to just find a definition of malicious within them?
Sure.
It doesn't look like there is a definition of malicious within the pattern jury instructions. There is a section on malicious prosecution.
Not the same.
Yeah, I know.
All right, well, that's good to know.
Are you and Chairman Nethercott, are you inclined to suggest we create a definition?
No.
Okay.
Mr. Chair.
Elise?
Mr. Chairman, there may be, in fact, I just did a quick Westlaw search. There are a few references to malicious and some definitions within Supreme Court case law. But those cases, as I'm looking at them now, are pretty old. It looks like there's a good definition in Elliott v. State from 1934. I don't know how
Still good?
how helpful that will be, but there is, I think there probably is at least some reference to that in case law that we could pull together if we're looking for what malicious means.
Senator Barlow?
Thank you, Mr. Chairman. So I guess my question is, I read the sentence that malicious is included in. Do we need malicious? Does malicious need to be a modifier there? Because if the force acted with the intent when exploiting, so it seems there's already been a determination of exploitation take place, and that is defined otherwise in current statute. Exploitation is a reckless or intentional act to take any person, power, da-da-da-da-da-da.
Yeah.
And there's so I guess my question is, do we need malicious because we already have a definition, at least for exploitation, which I think exploiting is based on, because it's in the same statute. So that's my query is, do we need malicious at all? And maybe that gets rid of that discussion, or at least we should inform ourselves to what exploitation means, because it is, like I said, reckless, intentional, temporarily deprive, et cetera, et cetera. Thank you, Mr. Chairman.
Mr. Chairman,
Please.
I think Senator Barlow provides an excellent solution to eliminate what would be a jury's decision to determine what is or isn't malicious based on 1930 case law, and which is still good law. And And he's correct in identifying that exploitation requires that type of overt intentional act that would typically be associated with the awarding of punitive damages.
So then, where did you find the reference to malicious in, is that in 117?
Mr. Chairman, so in the current bill draft, if that's what you're speaking, Mr. Chairman, on page 2, line 4, malicious is there.
Oh, there it is. I just couldn't find it.
Malicious
Thank you.
intent, but it is modifying when, it's modifying when exploiting, and exploitation is defined in current statute, in the same statute that we would potentially be adding this.
Thank you. I
And
just
so-
missed where it was
Yeah,
at.
my apologies.
Thank you.
Thank you, Mr. Chairman.
Should we go back and try and work the bill then? Senator
Thank you, Mr. Chairman.
Nethercott?
Mr. Chairman, yes, and I have an amendment if I can.
Okay. Get a little closer to your mic,
So,
please.
yeah, so this is working the bill. So,
Let's move the bill. Anybody want to move the bill?
probably a good idea.
We've been
Second.
moved and seconded. Thank you. Okay. Public comment on this bill? Thank you, Senator Barlow. We're all getting ahead of ourselves just a little bit. We'll get better. Thank you. No public comment. It's been moved, it's been seconded. Now let's come back. Senator Nethercott.
Okay, committee, so starting on page 1, this is just a combination of working the bill and then doing an amendment. We have the first sentence of the statute reading, "A vulnerable adult shall have a cause of action against any person who has exploited the vulnerable adult." And then moving on to page 2, this is where the amendment will be. Page 2, line 1, "The vulnerable adult may recover actual damages for the exploitation, and the court may award reasonable attorney fees." So what we're going to do there is change it based on the discussion that we just had. And so I move for an amendment on page 2, line 1 that says, "The vulnerable adult may recover actual damages, punitive damages, and reasonable attorney fees for the exploitation of the vulnerable adult."
Would you read that again? Make sure that staff has it.
The vulnerable adult may recover actual damages, punitive damages, and reasonable attorney fees. Period.
Is there further deliberation going? Is
That's
that,
it.
that's it?
That's it.
Any comment on the amendment? Senator Barlow?
Mr. Chairman, so just to be in fullness, on line 5, there's also speaks of punitive damages, and maybe Senator Nethercott's going to strike more as she goes. I just want to be clear about that, is moving forward, there's more amendments that need to be made, so thank you.
Correct. And so for clarity, we would be striking lines 2, 3, 4, and 5 up to that period on line 5 behind punitive damages in exchange for the one sentence.
Yeah, and don't we want to incorporate all that into the same?
Yes. Yes.
Thank you. That's. Any,
Question? Yes.
all those in favor?
Aye.
Those opposed? Okay.
So now, Mr. Chairman, we go into kind of the second concept of the cause of action, which is who may bring it. And so kind of oddly, the section starts off with who that is as well, which is the vulnerable adult. It goes into then the type of damages that could be received, and then it goes back to who can bring it. Won't deal with that right now. But so structurally, we're now on the topic of who can bring the action. As mentioned at the very beginning of the statutory section, the vulnerable adult can, the person's guardian or conservator, or the personal representative of the estate. when they're deceased. So I think and then there was a motion by Representatives Wanitzer earlier that wasn't untimely. So if he wants to make that now in order to incorporate the definitions as found in the Uniform Power of Attorney Act under statute 39116.
Yeah.
I would like to make that motion now. If Anna could help me with the language and how that reads, that'd be great.
And for clarity, and Anna, then I'm going to have you read this to make sure that we do have it right. You're going to insert this language after the estate of deceased vulnerable adult, or where?
Mr. Chairman, it probably, well, depending on what other amendments are made, I could put it behind conservator or after the language about the personal representative of the estate.
Yeah, I would, either's fine.
Either's
Okay.
fine. Just there any other person listed in whatever 116? Is that how it should read?
And Mr. Chairman, I would like to clarify this motion, if I can,
Please.
that this will not just reference the statute, but we'll list it out. And that way, when we work the bill in session, everyone sees it without having to go work for it. Because I do think that likely additional thoughts need to be provided on this listing as found in 116. But at this time, let's include them in there for consistency across the board. So it's
Okay.
not just a reference, but a reference plus the listing.
And Anna, have you found that?
I have it, yes.
So could you just read that as you feel it would be inserted in the bill? Read the sentence, including this new language?
Mr. Chairman, honestly, if we're going to add all that language, I'll probably have to candle it out and just make paragraphs.
Okay,
But I believe it'd be, the action may be brought by the vulnerable adult, that person's guardian or conservator, the principal or agent of the vulnerable adult, we've already, a person authorized to make healthcare decisions for the vulnerable adult, the vulnerable adult's spouse, parent, or descendant, and a person who would qualify as a presumptive heir of the vulnerable adult.
Yes, so Mr. Chairman, if I can.
please.
Yeah, just to add on to that for clarity, what I would envision is on page 2, line 5, the action may be brought by the vulnerable adult, comma, and those individuals identified in 39116 as found below. And then it's listed straight from the statute.
Okay, perfect. Do we need to include the definition of agent?
No.
Or reference agent? Okay. Okay, Chairman Zwaniter, is that your amendment?
That is my amendment in its entirety, Mr. Chairman.
Is there a second?
Second.
Any discussion?
Question?
Senator Barlow?
Thank you, Mr. Chairman. So I think there will be discussion when this comes up, because the last one in that list, Romanet 8, is a person asked to accept the power of attorney. Well, that is about as nebulous as can be. It doesn't say who is asking or why they're being asked or anything. So I just throw out that that while the list starts off with things that we understand, guardianship, conservatorship, relatives, and ends with something that I don't even know where that comes from or why that would have been included. I just throw that out there, that this list, also just incorporating the list or referencing the list, you go look at the list, there's these questions in my mind too. So anyway, thank you, Mr. Chairman.
You concur?
Mr. Chairman, if I can respond on the discussion, those are fair concerns by the senator, and I share those concerns, which is why I'm asking it to be listed for further discussion and evaluation before the Judiciary Committee and in session, and by anybody who would review the bill. Remember, this language comes from a uniform act adopted in all 50 states, I think, listing these individuals that have been identified as being closely associated with a vulnerable adult who should be able to question the actions of an agent acting on that vulnerable adult's behalf. And so typically who that is a person who's asked to be a power of attorney would be one son. And that son said, hey, Dad, I live too far away and I'm too busy right now. Why don't you have the other son do it? Okay. Other son starts to do it, is questionable. And so the one son comes forward, or a neighbor, right, that was asked to be a power of attorney, because the son would already have a standing. But that's how that comes forward. They had been previously considered by the principal or by the vulnerable adult to be their agent. For whatever reason, didn't, someone else did, and now their actions are questionable. That person has been previously identified as someone close enough to the vulnerable adult to have that concern.
Okay,
That's an answer, yeah.
well, it's a good answer,
Yeah.
thank you. Okay, we've got a motion, it's been seconded, question's been called, those in favor? Aye. Those opposed, if any? Continue on. Anything else?
I think that's the bill, Mr. Chairman.
Okay, we've been, is there any other amendments from anyone on the bill? We've been doing, I believe, a roll call on these, Katie, if we could.
Mr. Chairman, roll call for 24 LSO 0017.6 vulnerable adults, civil cause of action as amended. Senator Barlow. Senator Nethercott.
Aye.
Speaker Summers. Representatives Wanitzer.
Aye.
Co-Chairman Larson.
Aye.
Co-Chairman Baldwin.
Aye.
Director Johansson.
Aye.
Director Schmidt. Deputy Director Babbitt. Dr. Ballard.
Excused.
9 to 1 excused. The committee recommends to a standing committee.
Mr. Chairman,
Senator Nethercott.
I'll be quiet for the rest of the day, but I just want to pontificate if I can for a minute on this bill that we just passed. I think it's really important. It seems like this nuanced legal cause of action and the lawyers will deal with it, but there is a gap in the law about providing a remedy for this type of piece. As we've discussed before, law enforcement isn't sometimes equipped to really right a wrong in these circumstances, and we are now providing an avenue for that to occur in a very meaningful way. So I do think we've empowered the citizens of Wyoming and our vulnerable adults in a way that will actually see results for them and their families.
Well, and I would just suggest, Senator Nethercott, that I think that was the reason this task force was put together by leadership, was to try and impact and make a difference in the state. So we have no intent in gagging you or anybody else. This conversation, is important. So thank you. Okay, let's move on to LSO 0015, the vulnerable adult definition. We kind of put that on hold, as I recall, at our last meeting, kind of thinking that initially we hadn't heard back from a lot of the county attorneys and prosecuting attorneys. But those that we did, it was first in opposition, and we felt that perhaps that was changing a little. And so we thought that maybe we would hold off and work that again. So Senator Barlow, Senator Nethercott, Eric, I'll defer to you, but how would you like us to work through this?
So, Mr. Chairman, I don't think the subcommittee has anything further to add. We had no further deliberations. I did reach out to a couple of folks yesterday and just cueing them that we were going to be taking this up. So I don't know if our staff has anybody awaiting for public comment, and maybe that's the where to start, unless certainly I defer to Senator Nethercott if she has specific comments about how to proceed. But I did reach out to the County Attorneys Association, and I guess I also have spoken with AARP or exchanged email. So I see their representative here, and I don't know if anybody's online. So I don't have anything further to offer, Mr. Chairman. Thank you.
So prior to taking public comment and on that, I just, because we'd kind of called time out, and so I just will need a motion to move the bill. Do we feel like that we want to do that, or are we going to?
Mr. Chairman, if we may, if we recall, I think this bill draft is in front of this committee today because of my request to ask it to be published for another meeting date to continue to drive conversation in the state evaluating this topic. It's hard to write down what a vulnerable adult is or isn't. And so this committee and the legislature and all state legislatures have struggled with this. And I think it's just important that we continue to do that as our understanding of geriatric care changes and as an aging population continues to be a concern for our state and for legislators, that we will continue to have the need to evaluate these definitions, as hard as that might be because it is so ambiguous. But I just wanted to make everybody look at it again, to drive the conversation, particularly those county attorneys that we have heard criticisms of about their lack of initiative to perhaps prosecute these types of cases because the statute's ambiguous. Notably, they have no changes to the statute. Clearly documented, has been published multiple times this interim now, and multiple requests for their participation. So any further defenses that the legislature is to blame for any ambiguity in the law for their failure to prosecute is unacceptable. That's it, Mr. Chairman.
Thank you. Anna, do we have anybody online? We'd like to go to public comment. Anyone online?
No, we don't have anybody online, Mr. Chairman.
Any public comment from the public at hand? Okay, I have some, if we move the bill, I have some thoughts on an amendment, but so would we like to move the bill?
Mr. Chairman, I'm not going to move the bill, but I'd make a comment prior to moving the bill. I think that the significance of a definition, because it permeates statute, leads me to not want to actually advance this bill without some of those key stakeholders being a part of this conversation. Just going into just the logistics of where we are. A task force who cannot sponsor legislation going into a budget session. So if this task force is carried over to the next interim by management council, then I would say this could continue to be considered. But I guess as far as advancing it now, or amending it and advancing it, I just don't feel like we have a path for that. And we already have 3 bills, at least 3 now, that we've passed out of on this vulnerable adult that we're going to try to get someone to entertain as it stands. 2 that went to judiciary, you've already made contact with them, and the one we just passed on the civil cause of action that we still need a home for. And it might be a personal home based on the workload of some of our committees. So I guess I'm not comfortable. I mean, I guess I'm just suggesting I don't know that we should move this bill forward. We don't have the stakeholders in the room and where we are in the schedule. Thank you, Mr. Chairman.
Director Schmidt?
Mr. Chairman, and as being part of the discussions with the work group and also having had conversations with our team at DFS, we're comfortable with the statute as it stands right now. And I think that waiting until we have a little bit more conversation about the role of the state and what it is that we expect the state to provide might then better inform a definition if this task force continues into next year. But just for your purposes to know that we believe the statute meets our current needs. Certainly, there's always going to be opportunity to enhance it based on the evolution of this topic. So we would be fine and can operate under the current statute.
Elise?
Mr.
Butler, sorry.
Mr. Chairman, just a couple of things. We have talked about this with some judges within the judiciary, and we share the same opinion that the statute, as it stands today, works well for what it's needed to do. And there's been some, you all know, there's been some Supreme Court case law, interpreting the definition, and it's been interpreted fairly broadly. It is not from the 30s. Since 2017. So the other piece, just because I think it's been part of the discussion before now, and I just wanted to point it out, we did provide a report on the number of prosecutions that we have seen, the number of filings within the judiciary for violations of 62507, which incorporates the definition of vulnerable adult. So what you'll see in that report, and that's in 3-5 of your materials, overall, over the last 5 years, the total of prosecutions is 155 statewide. But what I will tell you is that some of those cases are duplicated because felony cases start in circuit court and are bound over to district court. So those cases are counted once in circuit court and once in district court. So this was kind of a quick report. We could do something a little more in depth, but we wanted to make sure you had those numbers as a reference as we're having this discussion.
Okay. Okay. Senator Barlow.
Thank you, Mr. Chairman. So I guess what will be interesting if we get the cross-reporting bill is then how do we cross-reference prosecutions with actual reports or investigations? At some point that should be the ultimate goal, is understanding as we get more information, as we coordinate more information, are we getting adequate prosecution? Because I don't know that we know all the cases that are being investigated, particularly on the law enforcement side. I think DFS can document theirs, and that's probably actually what's documented here, the majority of. We don't have that other part of that equation. So first step maybe actually is just to close that information gap. Anyway, thank you, Mr. Chairman.
Okay.
Mr. Chairman,
Senator Nethercott.
just anecdotally, looking at this data provided by the court, not surprisingly, it looks like there's a drop-off in general prosecutions in the last 3 years or so. So it's post-2020. Don't know if that has anything to do with it, or if the population was changed in some way. But certainly interesting, or if that had to do with an election cycle.
Mrs. Butler.
Mr. Chairman and Senator Nethercott, we did notice that when we were running the report. We tried to dig into the data a little bit to see if there was any reason for that. We couldn't discern any reason. So we don't know why the drop-off happened.
So, move the bill, going once, not seeing the appetite, will not move the bill. I would, though, as I think this will be an ongoing thing, I just would ask the committee to look on page 3 of the bill, the language there in C. And the reason that got my attention yesterday as I was reading it, and I don't know why it hadn't before, is when we talk about a vulnerable adult who lacks capacity and consent to provide for themselves from neglect, abuse, exploitation because of any of these following, and then A and B are kind of organic. There's emotional, developmental effects of illness or aging. Then we go to C, and it's because they've been put someplace. That seems out of whack to me. And so I would, as we move forward, I would probably suggest that we remove that language, and or if we think that that's an area where there is neglect, we put it in under some different language. But that's moot. We're moving on. So I'd like to go to LSO 145, the Vulnerable Adult Council. And the way this left us last time is we passed this bill, and the two chairmen had the opportunity to ask a standing committee to hear this. I'd like to come back and revisit this conversation before we try and push that further along. As I read the bill and we worked it last time, I just see a lot of similarities in this council as the bill is in its current state as we passed it, and what this task force is doing. And I would be more inclined to just continue this work on with the task force rather than pass it off to a council. And there's a couple of reasons. I think it's going to be difficult to get the council passed through the budget session. And secondly, I think that they're going to have to replow the ground to some degree, not fully, but to some degree, what we've already done. And so it stands to reason, at least from a Larson perspective, which is not always very good, that we would just continue this as management council decides that this task force should continue on for another year, that we just carry this forward. So I'd be interested in your thoughts. We passed the bill. We can still move it forward to a standing committee, but I just, as I've thought about that, I just want to see if anybody's had any similar thoughts. Representative Summers, Speaker Summers.
Some feedback somewhere.
It's a sign from God.
All right. Yeah. Don't pull any harder. Okay. So, I mean, we discussed this, inside our subcommittee. Sorry, I got a throat. Anyway, we discussed it inside the subcommittee, and ultimately, we decided it probably stood more clout if it came through a bill. Probably the agencies would have more reason to do the work. Frankly, we don't know whether this task force will exist next go around. There's 2 members of management council here, but I don't know how that goes, so it's up to the group how they want to do it. I mean, I'm interested in the agencies. I mean, the agencies can do this work, but if there's nobody to report back to, then will it, I guess they can report to the same place that the bill tells them to report to, which I believe is it's labor health, isn't it? Or is it, and maybe appropriations?
It's both, yes.
Yeah. So, yeah. So you're right, maybe it might be hard to pass it. And we put in a fairly short time frame to get it done. I mean, I would be interested in the agencies, whether they have any 2 directors, whether they have their thoughts now. That was our thoughts then, so.
Director Johansson?
Thank you, Mr. Chairman. I'm somewhat agnostic here. We can get the work done. I won't speak for Director Schmidt, but I think we're on the same page that with what this bill directs, should it pass, we can make those recommendations and report back. Maybe just a suggestion, because I agree with you, Chairman Larson, that a lot of this does fall into the mission of this task force, but to the speaker's point, maybe the task force does not get continued. We have had legislative direction in the Department of Health on bills or budget that should something pass or not pass in the session, you could have a trigger in the bill that way. And if the task force continues, then maybe the bill's not necessary. But honestly, I don't have a great answer, because we can certainly do the work should it pass.
Director Schmidt?
Thank you, Mr. Chairman. I agree with Director Johansson. I think when we discussed this in the work group, it really was about focusing intently on the work that's listed in the bill. If it goes before this group or if it goes before another created group, I think either is fine. My conversation is I do think we need to have direction, though, that states this is a priority, instructs the agencies as to what to do, and then we have clear understanding of what the guardrails are, and then we report back. Again, to whom we report back maybe doesn't make a difference, but that it's delineated what it is that we're instructed to do was more important.
Anything from corrections? Heather, any thoughts?
Thank you, Mr. Chairman. For us, were not obviously named in the bill, but I do think the work that's outlined in the bill is really important. I think they're really good questions as we just grapple with vulnerable adults. So I certainly support that the work goes forward. How that happens, I don't really have a dog in that fight.
So, ultimately, Mr. Chairman, we can do this as a set of recommendations. That doesn't mean that the governor has to do it, right? I mean, ultimately, he's the boss of these guys. We can direct it through a bill. But, you guys weigh in, but ultimately, there's a boss above you, too, that decides what work gets done. I don't care, whatever the pleasure of the committee is. We could just do it as a set of recommendations.
So I'm gonna do this. We're just gonna do by the raise of hands. And it's okay either way. If you feel that the council should be considered and this work be done as lined out in the bill rather than having the task force carry it forward this point on. In other words, we move it to a standing committee. Those in support of that, raise their hand. No, we're voting. We took the comments. Okay. We're not going to move it forward if I'm reading the hands right. Okay, let's move on now. Would you like to make comment, Chairman or Director Schmidt?
Mr. Chairman, it's okay. I wasn't sure I understood what the.
Well, I'm just trying
question
to, so move the bill forward. Do we send it to a standing committee or not? And the question was, do we move it to standing committee? Raise your hand.
Okay. Mr. Chairman.
Yes.
I'm going to make a motion that the contents of that bill be a set of recommendations to the two agencies from this task force.
Okay.
And that the bill be rescinded.
And the bill be rescinded.
Sorry.
And so let me make sure, so we're going to make recommendations from the task force, if I'm understanding you correctly, we'll make recommendations from the task force to those agencies on this matter. Perfect. Those in favor of Speaker Summers' motion, say aye. Aye. Those opposed? One no from a grumpy guy. Thank you. Moving on to LSO 0192. A little history on this bill came at a recommendation from one of our district court judges as we've been looking at this guardianship and conservatorship. And I'll ask Mrs. Butler to correct me if I'm wrong, but my understanding is once a court has assigned someone to be a guardian or a conservator, the clerk of court then issues them a letter of guardianship that they use as an official document to verify to whomever it is they're interacting with on behalf of the ward that they are indeed that guardianship. And then they are to make reports back to the court on an annual basis. And one of the challenges we have is sometimes guardians and conservators aren't getting those reports back to the courts in a timely manner. And so kind of as an incentive, if you will, to make sure that these reports get back, it's suggested that the letter is good for 1 year and will be renewed annually with the filing of the guardian reports. So the guardianship doesn't go away, but that documentation, that they use as official authorization isn't issued until they get the report in. So Elise, am I understanding that accurately?
Mr. Chairman, I think that was perfect.
Okay, good. And so that is the essence of this bill. Any questions before we go to public comment? So any comment online, Anna?
No comments online, Mr. Chairman.
Any public comment here? So pleasure of the task force to move. Been moved?
Second.
And seconded, thank you. And
Mr. Chairman, I have a motion.
thank you. Motion or amendment?
I have a motion for an amendment.
A motion. So we have a motion for an amendment, please.
So let me conceptually provide you my idea. A petition for a guardian or a conservator is somewhat arduous, somewhat. And so oftentimes these guardians and conservators are doing a lot, and they may be late or just delinquent in filing the report. And I have no doubt that the court will issue orders of warning to file that report and wait an appropriate amount of time. But that will be at the discretion of the court, because it's not automatic here for when that occurs, I don't think. If the failure to file that report. So conceptually, what I am thinking of doing a motion for is allowing a motion for reinstatement of the guardianship or conservatorship may be filed within 60 days of entry of the court's order terminating the guardianship or conservatorship if the report is filed and good cause is demonstrated, period.
So I want to make sure that I heard you correctly, that did you say the letter of conservatorship, or did you just say the guardianship or conservatorship?
So, Mr. Chairman, when I look, and I, in confession, I've just looked at this, knew about it conceptually from you, Mr. Chairman, but on page 2, line 16, it says cause for termination. And I'm assuming that is the termination of the guardianship or conservatorship, meaning there is no longer a guardian or conservator for what is a vulnerable adult. Now, this vulnerable adult doesn't have a conservator or a lawful guardian. Problematic. Now, it's concerning that the conservator and the guardian is not following the law by filing their annual report as required, which demonstrates and proves to the court that they are not exploiting that adult or causing any other harm.
That's right.
So it's really important that they filed that report. It's also really important that that vulnerable adult doesn't go without a guardian or conservator because of maybe a technical issue.
Got it.
Mr. Chairman, I think, and I can't lay my hands on it, I was looking through the statutes the other day. There is a statute that requires the court to issue an order to show cause before, if there isn't an annual report filed. Generally, what will happen is, the court will send a letter initially and say, please file your annual report. You are delinquent. If it still doesn't happen, they do an order to show cause. The guardian or the conservator is required to come in and show cause as to why they should not be held in contempt for failing to file that report. I think one of the issues that I've heard is happening is sometimes it's hard to serve those guardians and conservators. They can't be found. So even if you have an order to show cause, so in those circumstances, it would be very concerning, right? Because you can't find that person. And so termination may be warranted in finding another guardian and conservator. There is an extra step. I don't disagree. I think it's a worthy amendment. Just wanted to make sure. There is a statute. I can't put my hands on it right this second, but I will find it and I'll provide you that statutory reference.
So Senator Nethercott, I'm tracking with you now. I wasn't in 331101, but would you read that language that you put in there again? And if you want to do it conceptual, that's fine. We can have LSO.
Yes, and it is conceptual, and it may require further conversation of how the judge anticipates this working pragmatically, because we're adding a new concept into the guardianship conservatorship statutes, which is this letters of appointment, which is similar to a probate where you get issued letters testamentary in addition to an order appointing you a personal representative. I'm assuming that's the thought here, is something similar to that. And they would revoke the letters as opposed to terminating the guardianship or conservatorship, but that's not how this is written. So I have to go with what's before me right now. And we do want the ability of the guardianship or conservatorship to be terminated by a court sua sponte in the event that they have concerns that the guardian or conservator can't be found. That said, I think there needs to be a safety valve in that circumstance, recognizing that usually everyone involved in this circumstance doesn't have a lot of legal resources, which is why they're in this situation, and so they're doing what they can. But a motion for reinstatement may be filed within 60 days from entry of the court's order terminating the guardianship or conservatorship if the annual report is filed and the motion demonstrates good cause.
You have that on, and we can,
Make that better.
Mr. Chairman, I do have that. I might tweak it a little bit, but I have it.
Senator Barlow.
So, Mr. Chairman, well, I appreciate the intent. There's still a gap in conservatorship or guardianship. This still creates a potential 60-day gap in the way this is structured, period. The way I understand it, it still creates a gap, not maybe a longer term gap, but it still creates a gap. So if we're going to take this approach, we have to fill that gap as well. The court has to know that that gap is occurring, and that's what they are, and either appoint a temporary guardianship or conservator to fill that gap. And the reason I'm trying to parse this out with the amendment is under 331101, 4, Romanet 4 under that, this is this guardianship cease or conservatorship terminate, which is where we're at with this amendment. Number 4 is determination by the court that the guardian or conservator is not acting in the best interest of the ward. So maybe there's actually a sentence to be added there that says, or has not filed the requisite report, or whatever we want there. But in the next sentence, in that same section, it says, in such case, the court shall appoint another conservator or guardian. So the court is obligated to this. So now we're creating a gap legislative when the court, I think, is obligated to have, if there's not a determination of competency, age of majority, there's a couple other things, no longer necessary. So there's 5 reasons in current statute why you would end one. One of them is not because we didn't file paperwork. And creating that, I think, is, even for a short term, is challenging when the court is obligated to in current statute, at least the way I read it.
He's cheating. He has the book.
So the chairman's been directed to remind the members of the task force not to be cheaters.
Mr. Chairman.
What's the question?
Mrs. Butler,
Sorry.
please.
I was just thinking, it might be kind of worth thinking logistically about how this is going to flow through the court, because it's a little bit difficult to understand. So you explained it perfectly, Mr. Chairman, in the fact that, guardianship is ordered by the judge, and then the clerk of district court issues guardianship letters. So you get a letter that you use to do things for for the person who is your ward. And then if we put an expiration date on those letters, that means that after this year, that letter is going to terminate. And if the clerk does not receive an annual report by the time of that termination of the letter, then what I would anticipate is the judge would be alerted. The judge would then have to go through the process of issuing an order to show cause, bring that person in, if they can serve them, to say, why aren't you filing your report? And if there's not a good reason, or if they find that, that the guardian should no longer be the guardian, then at that point, I think it would fall under that provision that Senator Barlow pointed out, which was, a determination by the court that the guardian or conservator is not acting in the best interests of the ward. And then that second sentence would then kick in to say, okay, so now I have to appoint another guardian because this person still needs a guardian of some sort. So I think potentially that 1101, we may not need Romanet 6, and 7. We may not need those because I think the process would be, just because you don't file an annual report, right then your guardianship is terminated. It just means you're not going to have those letters to be able to use to go around and say, I'm still this guardian, even though I'm not acting in the ward's best interest, right? You have to answer to that in order to get that next letter to be able to use it. So I think that process could work, and I think maybe that means that we don't need
So she has a motion.
those amendments. Yes, I would so move.
And I would,
So-
I would second that.
Yeah, and so if I'm understanding the motion here is we would delete the new language in 331101, Roman 6 and 7, is that correct?
I think we delete line 16.
16 through the end of section 1. Keep section 2, section 3, right?
Yes, I second that amendment.
Okay.
Question? Did we move the bill?
Question on the amendment? Yeah, we did. You seconded it.
Mr. Chairman,
Yes.
just a quick question, maybe for Senator Nethercott or Ms. Butler, because we deal with this on the back end with folks in our facilities that have guardianships or conservatorships. So just for my own edification, and Ms. Butler makes a good point, the language on page 2, lines 1 through 14, does not impact the guardianship status. It's just the letter that's issued that acts as kind of the operative power for the guardian.
That's right.
So the guardian, what I want to be clear on is that we have, clients who have had the same guardian for decades. And I get the mechanism here of saying, well, you need to be available and renew to have that power, to have that letter, but the guardianship doesn't terminate after 1 year.
So when we started working on the language of this bill, we thought it was going to be a quick little fix, but the language really did conflict with that, and it led you to believe that the guardianship was terminated, not just that this letter is invalidated until you get your report in. And so I think removing the language, as you pointed out, I think so. You're correct. Okay, we have an amendment on, and a question being called. Those in favor of the amendment? Aye? Aye. Those opposed, if any?
Mr. Chairman?
Senator Nethercott.
I think this is a great idea, and I support it. I do wonder pragmatically its impact, because the world doesn't operate with letters from the clerk regarding honoring court-ordered appointment of a guardian or conservator. And so the guardian or conservator will show a bank or healthcare facility the court order appointing them as the guardian, not the letters. And so they'll still be able to fulfill their functions and duties if they're doing that through that court order, because the letter is a different document. But if it's a tool that the court can use in order to gain compliance for those reports, I think that's helpful.
Any thoughts?
Mr. Chairman, Senator Nethercott, it's of course a great point. I don't know if there's a solution, honestly, because the only solution would be that you put an expiration term on the guardianship itself. And I don't think anybody's very interested in doing that, and especially for a person who needs a permanent guardian. And so I think that would be really difficult for the guardian and for, the courts. It would be a struggle. So it's a really good point. I just don't know if there's a good answer.
Senator Barlow.
Thank you, Mr. Chairman. So my understanding is now we have stricken the 1101 language from the bill draft. And so we're now with two sections, the appointment of guardian, appointment of conservator. Both are basically identical language. And in section B of each of those sections, it says, these are what the order appointing the guardian shall state the findings of the court, including, Romanet 3 is, the duration of the appointment for a specified term or permanent, and then it's subjected to 1101. So the court already has the ability to, full latitude to go from forever to a year or 6 months or 2 days. So that in both these. So I guess my question is, And then 4 is a limited or plenary. Do we actually want to make this one of those duties and the recording requirement for that guardianship or conservatorship? So that is actually part of what the court, when they designate the guardianship, says, you're the guardian and you have an annual or a semi-annual or a every 5-year to someone who has been a guardian for now 50 years for the same individual who's in a facility. Do you want to have something there? So it's not something, we're not pulling it out. We're just saying the court says this. There is no bureaucratic process. The court just expects this and it comes in. Now, I don't know how that gets tracked. That's a different question. Anyway, I just throw that out there that right now it's a term or permanent. And now we're going to add this as another component of a annual something with no teeth in it. Anyway, I just throw that out there. I don't know how it fits, but I don't know we're getting to what we want to get to when the court could put terms on this, and maybe that's what we need to say. And any reporting requirements that the court may deem appropriate. And not do a 1 year, just say.
So I guess my question is this is after the court's made the appointment of conservatorship, and part of the process then after that has been determined by the court is that the guardian or conservator then has to be issued a letter of authorization, if for lack of a better term. And we're saying that then that term, that letter has to be renewed annually upon filing of those reports. Now, so are you saying instead of having that separate, put it back up in there as part of what the court is, when the court's making that decision?
Mr. Chairman, so what B says, the order appointing the guardian shall state the findings of the court, including reasons for the ward to need a guardian, the appointment, i.e. you are the individual, I assume, the duration and the limited and plenary duties of the guardian. How about we just add a Romanet V5 that says, and any reporting requirements that the court may deem appropriate.
And then
That's what we're getting to with this, I think.
Please, Ms. Butler.
So there is currently a reporting requirement for guardians and conservators within the statutes. So 32109 requires that the guardian file a report with the court on specific things about the ward. So the guardian shall present to the court and file in the guardianship proceedings a signed written report on the physical condition, including level of disability or functional incapacity. So there's a whole list of things that the report is supposed to provide, and then there's a timeline as to how often those are supposed to be filed. And again, it's just a check for the court to ensure that the ward is being taken care of. And so there's a similar provision, I think, in the conservatorship statutes, but the guardian's report is required under 32109.
Did that get where you needed to be?
I guess, Mr. Chairman, so the point being is we have a show cause. We've already talked about this. We have a hearing. We have a show cause. They can be held in contempt. So either we don't want to hold them in contempt, or the courts don't have time to follow up. And there's enough challenges getting people to serve as conservators and guardians that maybe there's part of the reason. So what's the evidence that we actually have malicious intent because reports aren't being filed? I mean, what's the concern that I think came from the court, from maybe the Chief Justice? What's the concern? What are we trying to fix with this legislative approach that the court can't already do in some way now? Thank you, Mr. Chairman.
So as I understand it, the requirement that Mrs. Butler referred to, that the reports are due, are there, but there are no penalties, there are no punitive anything that, and I think that was the reason the district court judge wanted this, to say, not to do away with conservatorship, but just to put some level of penalty in there, to say that letter of authorization will now be renewed annually as you file those reports. Am I got that right?
Yeah, Mr. Chairman, I think there are two pieces here, and actually this originally, I believe, came out of the task force report from 2017. One of the recommendations in that task force report was that you put an expiration date on at least the letters of guardianship and conservatorship. And the reason for that is if people have a letter of guardianship or conservatorship, and the order of guardianship or conservatorship can be used too. So there's an argument against this. But if they have those and they're using that authority and they may no longer have that authority, right? So the guardianships could be terminated, but if there's no date on that expiration date on that letter of guardianship or conservatorship, they can still use that when they go to a bank, right? And say, I want to withdraw $15,000, and the bank doesn't have any way to verify whether or not that person is in fact still a guardian or a conservator. And so I think part of the problem we're trying to address here is to allow for those people or those entities that are receiving those letters of guardianship to know whether or not this guardianship or conservatorship is still in a place. Right now, as I understand it, there's no expiration on those letters. And so that person may not be a guardian or conservator anymore. But if I'm a bank, I don't actually know that based on the document I'm being provided. And so, yes, absolutely. One of the reasons is to ensure that there's compliance with the annual reporting. But also the other piece of that is to have some kind of mechanism to ensure that this person is not acting outside of their authority.
Please.
Mr. Chairman, so thank you. So statute allows permanent guardianships and conservatorships, period. If we want to address that, we have to take out permanent from statute and say a specified term, period. So that every guardianship or conservatorship, and the court can make a judgment call every 1 year, 5 years, 7 years. You want to review this every 1, 5, or 7 years.
Mr. Chairman?
Thank you, Mr. Chairman.
Senator Nethercott.
I think Senator Barlow is highlighting what would be the confusion to the public by moving forward with this plan. So it's a bit of smoke and mirrors, I would say, in order to gain compliance of filing the report. The failure to reissue a letter does not terminate the guardianship or conservatorship, nor does it terminate that lawful authority as the guardian or conservator. It's just a piece of paper that the guardian or conservator will have that says, this expires unless you file this. And that has power. It's an official document. Now, some members of the bar believe that that is an effective tool that they'd like in the toolbox. Others, it sounds like, believe it can create unnecessary confusion and has no practical effect, as I indicated. So that's the concern. I don't think we need to mess with permanent or temporary. That is decided at the time a petition for a guardianship or conservatorship is established, where you ask whether or not this is going to be permanent or temporary. I mean, it's a rare circumstance that you would have a temporary guardianship, but certainly that could occur, and there'd be unique circumstances. But if you're dealing with a vulnerable adult, more likely than not, it's going to be permanent. And so it's always permanent. The question is, when does the court have that right, or anyone have that right to terminate that authority? And as the senator pointed out, the statute is clear that we have determined historically that the failure to file a report is not grounds in and by itself, arguably, to terminate that guardianship or conservatorship based on the rationale we've all discussed here today. But the court's then only remedy at that point for a failure to file a report is to issue a warrant, ultimately, potentially, for the guardian or conservator for failure to file that report. I don't think they don't want to do that, right? Order to show cause, order to show cause, order to show cause. The person doesn't appear. They have to hold the person in contempt. I think they can only be prosecuted for that. I don't know. It's a whole different. I've not pursued contempt charges before, but it's a difficult thing for the court to manage. And so they're asking for a tool in the toolbox in order to gain compliance to ensure that these wards are properly cared for. It may not make sense. And arguably it's meaningless. So it's a policy decision for you to decide. And I was not a part of these conversations. I'm learning them all right now, but so maybe more background about that would be helpful to know the pros and the cons, how much effort there is to move this forward or how much.
So it's interesting, the conversations we have here are similar to the ones Anna and I had with the justices, and we kind of got over that hurdle and got to where you're at, that it's not the conservatorship and the guardianship that's being impacted, it's just that letter of authorization and trying to get compliance. If there's confusion here and we don't have the language right, or if we don't, we can certainly table this and come back and make sure that we've really are addressing the issue appropriately. And so I'm sensing enough confusion that I think that's probably what we ought to do, is just table that for now, and we'll visit with the courts a little more and try to gain a little more understanding, have some conversation, and then determine whether we revisit this in September. Anybody opposed to that? Okay. Let's take a break till 10:45 and we'll be back. Staff and committee, I think we're going to get reconvened here. Little housekeeping that we need to do at the recommendation of staff is we made a motion not to move the Vulnerable Adult Council forward to a standing committee. We adopted that at our last meeting by a roll call vote, so they suggested we do a similar action to not move it forward. So we'll take a roll call vote on that action. If you vote, if you vote aye, you are voting not to move the bill forward to a standing committee. So, Katie, let's go ahead and do that.
Mr. Chairman, excuse me, this is motion to rescind the motion for the Vulnerable Adult Council 24 LSO 0145. Senator Barlow?
Excused.
Senator Nethercott? Senator Nethercott? Speaker Summers? Representative Wanitzer? Co-Chairman Larson?
Aye.
Co-Chairman Baldwin? Director Johansson? Director Schmidt? Deputy Director Babbitt? Dr. Ballard? 9 aye, 1 excused, in favor of rescinding.
Thank you for that. Let's move to LSO 174. This is a bill that come out of the vulnerable adult. And with the work that we have done in the behavioral health redesign, we established priorities. And the conversation that was there is how to include vulnerable adults in that priority population. And if you look at the adults with severe mental illness, well, we had two options. One was to insert vulnerable adult in that section of 35 and to have it listed as a priority population. However, most of the conditions that a vulnerable adult has is in there. And so working with the speaker, we kind of worked to having the definition of adults with severe mental illness, which is a priority population, amended to include, as you see on page 2, adults with severe mental illness shall include vulnerable adults as defined in 352102. So that they would be a priority population in receiving those services through community mental health centers and that we fund with state general funds. So any thoughts or comments on this bill? Any?
Mr. Chairman?
Yes.
Mr. Chairman, I think it makes sense to put it in that definition, and we achieved the goal of what I think was intended to make sure that those folks that are being identified and served, potentially in the future, served differently, either through adult protective services or through other services like these. Makes sense to put in the definition. I do think in the majority of cases, the vulnerable adults would fit into the priority tiers, but I think it clarifies it here that the intent is that, as defined in 3520, they're part of the definition under our priority population. So I think it's good.
Thank you.
Mr. Chairman, you and I worked that out a few days ago, and I'm good with it. And so I can move the bill, I guess, if you need that.
Anna, any public comment online? Or,
No public comment, Mr. Chairman.
any public comment? Ms. Somerville, welcome. It's good to see you.
Thank you, Mr. Chairman, members of the committee. Andy Somerville, Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers. And just to be totally transparent, not all of the directors of the community mental health centers have seen this language yet. And so there may be some additional feedback that comes to me from this. I think the only question that we might really have in terms of this, I think I we agree with Director Johansson that the majority of these vulnerable adults should be caught by these priority population tiers as they're laid out. But we do want to clarify exactly, what is the expectation for services for this population from the community mental health centers? Is it, some type of case management? Is it specifically related to mental health and substance abuse treatment? There's a number of different agencies or programs that work with, I think the old definition includes something along advanced age, so that there are maybe some other programs that would be providing services or working with this population as well. And I don't know that that's something that needs to be fleshed out in this bill, but it's just a question that we have in terms of what the scope might be.
Director Johansson.
Thank you, Mr. Chairman. And to that, it's a good point. And the way I see this is just like we're defining all of the other priority populations that would qualify someone for services that the community mental health center provides, not extraneous to that. So obviously, folks like this and others interact with a lot of different services and programs, state funded or otherwise. My understanding here is that it would qualify the population for the same thing that, an adult psychiatric population from the state hospital or the corrections involved clients would as well.
And I might add, there was some conversation, particularly depending on, with the conversation being that all vulnerable adults are not created equal, right? And so you may have one whose assets allow them, that's going to put them above that 200% poverty level that we get into here. That would require then they use their assets. But if it was below that falls into this adults with acute mental illness or indigent care clients, it fits under there. Really, more importantly, just bringing to light in this statute that we're focusing on these priority populations, and that does include vulnerable adults that you would find in this other section of statutes. If that makes sense.
Mr. Chairman, it does. Thank you.
Thank you.
I'd be happy to answer any other questions.
Any questions for Ms. Somerville? Any other public comment? Okay, committee. It's been moved and seconded. Any additions or corrections to the bill, that amendments proposed? Question being called. Katie?
Mr. Chairman, roll call for 24 LSO 0174.5 Behavioral Health Redesign Vulnerable Adults. For committee recommendation, Senator Barlow.
Excused, sorry.
Senator Nethercott. Aye. Speaker Summers.
Aye.
Representative Wanitzer.
Aye.
Co-Chairman Larson.
Aye.
Co-Chairman Baldwin.
Aye.
Director Johansson.
Aye.
Director Schmidt. Aye. Deputy Director Babbitt. Aye. Dr. Ballard.
Aye.
9 aye, 1 excused for recommendation to committee.
Yeah, just looked over at my good chairman and now looking at the other chairman of Labor and Health to see if they think that would be a good home. And I got a thumbs up, so we'll send it that direction. Thank you. Okay, we are now at that point, Director Schmidt, where we've asked you to come back and talk to us a little bit based on our last meeting, direction of where, with the conversation, where we're at and what it is we really are trying to get at the end of the day, where we need to be getting to. You have a slide presentation. We'd like to turn the time over to you.
Thank you, Mr. Chairman and members of the committee. This presentation is really to start to dig into some of the areas of this discussion where there really isn't clear-cut guidance on the role of the state, the role of the department, and the roles of committee or community members. And We're going to go through this presentation in a little bit of a backward way. We're going to talk about the continuum, but then we're going to start at the most severe of the continuum, because I do think that's probably the easiest group to talk about, and then start to get a little bit more into the gray about people who are showing tendencies to maybe severe, but aren't quite there yet. So Katie is going to advance the slides, right? Okay. So a little bit of background. Unlike the world of DFS, where we deal with protective services around children, there really isn't any federal law that tells states how it is that organizations, basically protective services, should engage with vulnerable adults. There's no national legislation. There is some funding, and some of that federal funding, most of it goes to the Department of Health, is really around older Americans, but not necessarily around vulnerable adults. As a result, we have a lot of inconsistencies across the US with how it is that vulnerable adults are treated, whether that's supported through case management, whether that's in the definition that came across. It varies from state to state. So what this is saying is really it's up to Wyoming to decide what Wyoming's role and responsibility is in regard to vulnerable adults, or those adults that are on their way to becoming vulnerable. So next slide, please. So the policy questions that we're going to ask right now and to be considering as we walk through the presentation, and then we'll also be asking at the end, is what is the role of the state? And I think we've been dabbling in that conversation through the course of the presentations and in the previous discussions. But this particular question, I think, is valid because we are engaging with adults who have rights. Unlike children who usually have some sort of guardian or parent who is dictating the care of that child, adults have their own rights unless then there's been guardianship. So there's a lot of potential there then for people to assume what it is that the state should or should not be doing when engaging with this population. And then what is the role of the community? And this is a question that we ask a lot through human services. The state can be there to provide structure, to provide money, but at the end of the day, communities like to have, and I agree, the autonomy to really develop what are the services they need to be providing locally. And in this population, community is a huge part of the service continuum that vulnerable adults rely on. And then what are the gaps in services or the systemic barriers? We've been addressing a lot of the systemic barriers through the conversation this morning around legislation. But it does come back down to, though, one of the biggest barriers being around adults who are vulnerable, who have no caregivers. They may have guardians, but potentially don't have caregivers. That's a question about a systemic barrier. And then after the state, whoever that is, whether it be the Department of Family Services, the Department of Health, once we are done with our work, our casework, and it's time to close the case, who is responsible for the ongoing care of that adult? And while that may seem like an easy question, well, of course, it's the adult. A lot of times when we're closing cases, what we are needing to close that case is a lot of community support and services to that adult so that we can prevent opening another case within a few days. So those are the policy questions that we ask you to please consider as we work through this presentation. So looking at this continuum of vulnerability and the role of the state.
Dr. Schmidt, can we ask questions as we go?
Sure, please.
So on your last one, and that last bullet where it talks, just trying to get it clear in my head how to see if I see it the same way it's being implemented. So when somebody receives emergency services in this slide, you're deeming that they're being brought into a system, right? And so when you're saying an individual is transitioned out of the system, it may be out of that particular system if they don't need, and out of the state system altogether if they don't need anything else, but it could also be transferring to a different system, or is there just one system? I think that that can be confusing as we're trying to do it. So what's this system that you're talking about?
The system, Mr. Chairman, the system that we're speaking about here is with the case coordination, care coordination of the Department of Family Services and also the court. So it's that legal system somewhat in the case management system that we can open under our authority, under our statutes.
And so when somebody transitions out of that system, they would have, again, been deemed cured? And I don't know the right term, but they don't need, there's no more court participation, or there wasn't a need for court participation, no more case management. So are they then, and maybe they needed some emergency services, got that. They're notified, this is, you know, you're done, go well, walk into the sunset and be happy. Or if there's additional, if there's still maybe a guardianship is contemplated or something else, is that staying in the system? Or is that moving to a different system?
Mr. Chairman, that is either allowing the family to continue as they do without any other DFS intervention or court intervention, or it could possibly be moving into an adult system such as what's offered through the waivers through the Department of Health. So that could potentially be a different system, but this is specifically talking about vulnerable adults as it applies to DFS case management.
Thank you. Representative Summers.
So, Mr. Chairman, just, you know, so I have it in my head, because you get a report, right? You get a report, and then they have to open a case on that report. That report is investigated. Ultimately, you know, depending upon the level of intervention that might be needed, you could either do a few things with your community support, or, you know, if it's severe enough, then you have to go to the courts. But really, every report that you get, whether it's from law enforcement or the neighbor or whoever, that's the system. It's just a reporting system that then you have to open a case file. Is that right?
Mr. Chairman, Speaker Summers, I think if we could move to the next slide, and then we can kind of go through. Here it is that we see as the continuum of vulnerability and the role of the state. So system as we define it actually kind of starts at the second, third, fourth, second on bullet. So looking at low risk or low or no risk, somebody may call us because they have some concerns. At that point, that person is not necessarily involved in the system, so to speak. We're going to talk to that reporter, we're going to ask some questions, and we may say there is no role for the state in this particular report. So we have a report, but a report doesn't necessarily mean that that person is now engaged in the system. So the individual has limited risk factors. There may be some risk factors as we move into the right. They're homeless, they have untreated mental health, there's isolation. But again, is that person vulnerable at that time? Probably not. Under the definition of what we see in statute and policy, are they vulnerable? Probably not. What we will do is we may open a voluntary case if that person wants to work with us, and then we can try to help them connect to services. But at that point, this person's involvement in the system would be voluntary. We don't have any way to say you shall go to this particular provider and get these exact services. So then as we move further in, there may be no allegations of abuse, neglect, exploitation, but there's some risk factors. We're starting to see a little bit more of, there isn't a hardcore definition, meeting of the definition of vulnerability, but we see it coming. And this is that gray area. This is where we maybe see some behaviors by an adult that if those behaviors are allowed to continue, it will put them into a situation where they are vulnerable. And an example of that might be a hoarder. So you have somebody who's elderly, 60 years or older, they're living out of town in a trailer house, They have no running water. They have no, potentially no heat. They're competent. They understand that they have no running water, no heat. They want to live there because that's where they live. But what we know from our case interaction with them is that one bad winter, they're going to be a vulnerable adult. They are not making the decisions that are in their best interest. And then we start to move further in. And that would be around self-neglect. And that is the area then that I think is the biggest question about, at that point, what is the role of the state? So then we move into vulnerable and abuses alleged. So now we have true indicators. A report is made. We have concrete evidence or concrete testimony that says this person has alleged to be abused, neglected, exploited, or self-abuse. This is where we will start to investigate. And that is where we really start to look at an intervention that may be more than just what a person would accept voluntarily. And then vulnerable and need in emergency services, then that's where we're jumping in. The court may be getting involved. We will be involving the court at that far right. In the one that's where there's allegations, we may not be involving the court yet, but it's going that way. But when we're at that far right of the continuum, we are involved, and it is temporary. And that's part of one of the legislation that we had talked about last time in this group, was for how long can those services go? How long can we investigate? And how long can we use the court then to be able to enforce those actions that we could not enforce through a voluntary type arrangement? So this is using a legal apparatus to be able to compel the person to act as we would hope they would act. Then behind all of this are the services that would come to support all of it. And those services may be the same services all up and down the continuum, but the difference here in this particular vulnerability and role of the state is how much of our will are we able to impose on a person to make the condition better. So does that help, Mr. Speaker, with your question? Okay. So there is a typo on this, not necessarily a typo, we didn't frame it as well on the last bullet, but I'll get to that in the last question. So when we're trying to identify risk factors, one of the first things we're going to be looking at, when I say we, it's the Department of Family Services through our caseworkers when we've received a report. We're first going to say, all right, does this individual meet the vulnerable adult definition? Is the person 18 years age of older, or is the individual unable to manage and take care of himself or his money, assets, and property without assistance as a result of advanced age, physical, or mental disability? This is that definition that we really talked about earlier today about, is this enough of a definition that whoever is concerned about this individual can act? For our purposes, us being the Department of Family Services, if the individual meets this definition, then that gives us permission to start to get further involved. Another question we're going to ask, is the individual a victim of alleged abuse, neglect, or exploitation? Okay, so has there been an accusation? Has a reporter, law enforcement, anybody that we engage with say, this person has been abused, this person is being neglected, or this person has been exploited? Then this is going to increase their vulnerability and go further right on that scale. Does an emergency exist, or is an emergency imminent? That's going to take us right to that far end. And then the last question, though, is really getting at, does the person have capacity to consent? What is their ability to understand and appreciate the nature of the consequences of making one's decisions? Really what this should be, if no, that again is going to push that person to the further right on that scale of vulnerability. So next slide, please. So also, though, we're going to be asking ourselves, or asking the question of this adult, thinking about what do they have in place that may help with their vulnerability, that may mitigate some of their vulnerability. The first one is, do they have a caregiver? And caregiver being used a little bit more broadly than a family member. A caregiver could be an assisted living. A caregiver could be a facility, a skilled nursing facility. It could be one of the Department of Health facilities. But is there somebody who is charged for taking care, physical care of that person? If the answer is yes, then the vulnerability of that particular adult is probably mitigated a little. Does the individual live in a community that has sufficient community-based resources for older adults or adults with intellectual disabilities or developmental disabilities? This starts to get at the very rural nature of the state. In some of our communities, we do not have, as we all know, the array of services, and some of these underlying services are going to be really important in addressing the vulnerability of that particular adult. And then, does the individual have access to resources? Do they have money to access those resources? Do they have transportation? Do they have someone who can help them get from point A to point B in order to go to medical appointments? Do they have a physician locally available? So resources being almost everything under the sun, but the ability to get to that resource, because it may not be, even if it's not provided locally, can they still have access to it?
Ms. Babbitt?
Thank you, Mr. Chairman. Director, I have a question about the capacity to consent, and this is where I struggle in our discussions about vulnerable adult, and I wasn't sure in your conversation. So if an adult has the capacity to consent, isn't that the end of your decision tree? Or like in the example you gave, the individual living, out in the middle of nowhere and it's cold and it's winter. But if that person has the capacity to consent, what happens in your decision tree? Isn't it that your authority ends there unless the person is willing to listen to you and discuss options for care? But doesn't that end? Where does your authority begin and end with someone who has a capacity to consent?
Mr. Chairman?
Please.
Ms. Babbitt, yes, our authority ends, but our responsibility doesn't necessarily end. Because again, that is the question. So if they're vulnerable, but there's been no abuse and there's consent, but that person is on their way to becoming vulnerable, what is the obligation of the state to continue to offer or provide services? And the state, in this case, being the Department of Family Services. So yes, we can terminate our investigation or our case at that point, but that does not mean that there are not services that are necessary to continue to support that person.
So Director Schmidt, on that third bullet there on does an individual have access to resources, seems to me to be the challenge that we have in Wyoming, not just in the physical presence of resources. We have a population that those resources are located just not in abundance and in areas where a lot of people don't live. Is that a fair assumption? And then the second part of that question is, and I guess that's what we're trying to figure out, is how do we make the limited resources accessible to the entire state? Is that correct?
Mr. Chairman, yes, the lack of density in our state makes access to resources very difficult. As we're spread out, as we have a lot of rural living, even living that's beyond rural, yes, I think getting those necessary resources to that person or that person to those resources is a big part of this discussion.
So can I kind of follow up on that, because we keep talking about, somebody maybe lives in Farson or, a small town, Table Rock, some place that's just out there that does it seem responsible as we look at your agency, because the same challenge exists for our children, meaning that they live, and so does your agency, is that the greatest resource then to these people, is through your agency to get access? Am I making sense with that question? I'm just trying to see how in these more remote circumstances, the families or the people who are concerned about vulnerable adults, where do they try and attach to learn or gain access? Just like, and so I equate that similar to children. If there's a CHINS or protective service, there may not be a field, an office, DFS office there, but they somehow know that that's where they go, right?
So, Mr. Chairman, I think maybe to answer that question and to compare and contrast it to our child welfare system, one of the major difference between what DFS can do for children compared to adults is to place a child somewhere where there is a resource. So we have the ability, if a child lives in Farson and needs a very high level of mental health care, and that child has been abused or neglected or is a child in need of supervision, we have the authority to take that child out of that community and place them where they can get those services. If you have an adult that needs that same level of service, the best that we can do is to try to talk them into going somewhere where they can get that service, unless the court then provides an emergency service. For example, if they need hospitalization. But at the end of the day, they go back to that home if that's where they want to go and if they're competent.
But refining it just a little bit and taking out, if they truly are vulnerable and the court is involved, then you do have authority to put them someplace? Or is that a court-ordered, similar to a court-ordered COP, right? And so, but the situation's similar in both, that you'd want the child to come back home, and hopefully the home would be in a position there to then take care of the children, and then that situation may not be that much different for the adult. You're hoping to rectify the deficiencies at the home, whether that be maybe we need a guardian or something in place when they do return. Am I seeing that accurately?
Yes, Mr. Chairman, I think that's accurate. Our job through the case management is to locate all of those services and try to connect the adult with those services so that they could return home safely.
Now, with the children, we sometimes see us having to step back away from the bank and get a run to jump the ditch to get over to clear that gap to get over to the next agency that has responsibility, whether it be Department of Health or Department of Education. Do we have those same silos that potentially exist then when we start looking at these services for adults? Is there a combined effort, or is there, who coordinates that, if there is a coordination?
Mr. Chairman, our caseworkers will coordinate a lot of that, and that is one of the things that they will do. So, for example, we have a vulnerable adult, maybe they've been financially exploited, they have no resources, they need a higher level of care like skilled nursing facility. We are going to work with that vulnerable adult to facilitate an application to Medicaid to see if they are Medicaid eligible, and then we will help them work through that system, which is a little bit of a different system at this point. That is the Department of Health system for whatever services they may have available per eligibility. That would be the same case with a younger person who is intellectually or developmentally disabled and is also a vulnerable adult. Maybe he's 19 and also then potentially qualifies for services under a waiver. Our caseworkers will work with that person and work with whoever at the Department of Health to try to coordinate all of the stuff, the documentation, the assessments, all of the materials needed to submit an application, and then in the meantime, be working with that adult, that vulnerable adult, to try to find somewhere where they can be until eligibility is determined and the services begin. And that is a lot of where we spend our time and energy.
Thank you.
Okay, continuing on. So the emergency services was kind of the questions that were outlined in the agenda. And the emergency services are the most extreme cases, but they're also the fewest. This is really where the system has said nothing else available in the community for whatever reason can get this person what they need. We need to compel this person to get what they need. So in this particular situation, if you go to the next slide, we're going to talk about emergency services more from kind of a legal and very policy-oriented standpoint. So if we have reason to believe that an adult is suffering from abuse, neglect, intimidation, self-neglect, exploitation, or abandonment, an emergency exists, and there's inability to consent, we are going to be looking to a guardian, if there is a guardian. We're going to be looking to the court to be able to help us put some of these things in place. So for example, we have someone who is not necessarily mentally ill, because if they were mentally ill, possibly Title 25 would step into this process, but rather they just lack the capacity to consent. They're in a very extreme situation, and we need to get them removed from their place right then. So if they're in a home and there's a family member that's physically abusing, we need to be able to remove that person, get them where they need to be safe. That's going to require court. We don't have the authority to take protective custody.
What's the response time on that? So you find that adult, they need court intervention. Is that immediate? Is that a number of weeks? How does that play out?
Mr. Chairman, I don't know if we necessarily have data to support that, but I think my experience with children says that the courts are going to be very responsive. The county attorney is going to be very responsive. If there's an immediate need, then yes, I think the system is going to respond just as we do with children. But in terms of how long that actually takes, I think we could look into some of the casework to provide better information.
So, Mr. Chairman, so what happens, when before you can get a hold of a judge, right? So somebody calls the cops go in, situation's horrible. Cops pick the individual up to secure them basically from further abuse or whatever's going on there. And then how does that, or does that happen? Or do they just leave them in the situation and call you until the court can react? How does that work?
Mr. Chairman, Representative Summers, can I phone a friend on that one? May I ask we have our staff here that can maybe provide a little bit more of that detail.
Come on up, ladies. Please share with us your names so we have it on the record and people at home can send you vicious emails.
Got it. Okay. Thank you. Mr. Chairman. My name's Jane Carlson. I'm with the Department of Family Services, Adult Protective Services, and I am the program analyst. And I also spent a lot of time doing Adult Protective Services casework. So could somebody repeat the question?
Representative Summers.
So the question was, let's say the police get a report, the police show up, and they find a situation that they feel is dire, right? And so they either pick that individual up to move them out of that. That's my question. Do they pick that person up and move them out? Because I think that has happened in the past. Or do you have to leave the individual in whatever squalor they're in until you get the court to react?
It's not an easy answer.
Ms. Cross.
Representative Summers. It's not an easy answer. I've seen it happen both ways, just in my involvement with casework. So, and I speak best in examples, so I apologize for that. So there was a time where an individual like you had just described was in squalor, but she wanted to stay in her own home. She did not lack capacity. So what happened was the caseworker petitioned the court, got this person into court. I think it was about 20 days later. And she was physically disabled. Her home was a hoarder's home. And the judge said, yeah, let's get you out of there. But she got to make the choice because she, didn't lack capacity. So in the face of everybody at the court hearing and everything like that, she did choose to go to a nursing home. Another example that I have is a lady who had Parkinson's disease. She fell on the floor and got caught between, just wedged in between her bathtub and her sink. And she did not lack capacity, but the police officer that I phoned when I knew that this woman needed help opted to get a hold of the county attorney and pull some strings to get her out of there right away. She didn't want to go, but they made her go. And essentially that, I think what happened was they did the Title 25 for her. And then they rolled it into a Title 35, which is our emergency services petition. So hopefully that answered some questions, but if the individual does lack capacity, once again, it just depends. It varies county by county. But from a DFS perspective, if an officer isn't willing to get the person out of the squalor as soon as possible, from a DFS perspective, we would try to call an ambulance. Once again, the adult can refuse, but we would try to file our Title 35, the 107 statute.
Thank you. Director Schmidt.
Okay, so back to emergency services, and Jane, you may want to just stay.
Yeah, I would, don't run away.
So means that those services may be provided to assist. One of the barriers that we have in this particular area, though, is who pays. So if we do have to, if an adult needs to be out of their home and placed somewhere and they have no pay source, then the Department of Family Services can pay and will pay for temporary housing for that person. But again, that's limited.
So in your budget, where's that at?
Mr. Chairman, technically, it's in our state level budget, and it's about $80,000 a biennium. 80. And we use those dollars very judiciously, so we're very hesitant to overexpend in any particular area, understanding that the dollars are few and the need can be great. And I think housing is one of those areas where we could see potentially pretty big bills if we can't find, for example, waiting on a Medicaid application so that that person then may qualify for Medicaid and therefore eligible to be placed in a skilled nursing facility if they meet the medical need. But housing that person until that process happens can be expensive.
What type of housing options do you look at 80,000 for biennium in a, seeing the report that there's not a lot of these cases, but that's pretty thin butter across the bread.
Mr. Chairman, for some of our elderly, we'll look at motels. That's one of the options that we'll use. For our younger people who are intellectually or developmentally disabled, we look at group homes. I'm not sure what they're called under the waiver now, but those are those group homes for people with intellectual developmental disabilities. And we will use some of those funds that are appropriated to us for vulnerable adults to pay for their care until there has been some designation made by the Department of Health as to whether or not they qualify for the waiver. And then, of course, waiting lists with the waiver, how long will it be before they actually can receive the funding to provide that service?
And how long, so you find this person isn't enrolled in Medicaid, qualifies, how long does that enrollment take?
Mr. Chairman, I would defer to the director.
30 days, 60 days?
Mr. Chairman, it varies, but I can pull some of those numbers. It depends on DD waiver and the assessments, the evaluations that are needed versus long-term care waiver or community choices waiver, which has a different functional assessment typically provided by a public health nurse to see if the person qualifies under Medicaid to be placed in skilled nursing. And then that waiver, instead of going to a facility, would allow in-home services. But the application time varies, and there's some variables in there of when the materials that are required, when they can be completed by the participant or potential participant.
So I think for the sake of my question, I'd be thinking of those that are long-term care, the choices waiver, not something that'd be going into a DD or ID situation, but where we would be maybe potentially housing them in a motel or some other such. I'm just trying to get my head around how long we might have them in emergency housing in a motel before we had Medicaid that would allow them to then.
And Mr. Chairman, let me get with staff and see how that would look on that side of the fence. I would just say, for the sake of this discussion, assume no less than 30 days to adjudicate an application.
I think that's good.
But I think it's
Just curious.
longer.
Okay, thank you.
So, Mr. Chairman.
Yes, Representative Summers.
So, Mr. Chairman, let's assume how often with adults like this, are they Title 25 when the police step in? So really not, do they Title 25 sometimes because they have to, because there's no other mechanism to do anything else with? And so then that person's probably taken to a bed somewhere in whether it's a hospital or whatever that situation might be, where they can Title 25 them. I guess the question is, how do they make that call? And is it just out of necessity? Is that the right call? Is that the right system for that individual?
We're going to defer to Jane.
Mr. Chairman, Representative Summers, thank you. Once again, not an easy answer. Lots of gray areas that we at Department of Family Services deal with. So the answer to your question is yes. If the situation is dire in that regard and there's just no other recourse, then the Title 25 really is the only answer immediately, for an immediate type of solution. But it is up to the county attorney, the police usually, or the sheriff's department, whichever side of law enforcement you're dealing with. They usually won't make any move in that regard without the county attorney, district attorney saying, yeah, let's do this, and I'll work it out in the court system and stuff like that. So in a dire situation, sometimes, as I was saying, where the county attorney perhaps isn't willing to, consent to the Title 25, then the Department of Family Services, seeing the emergency as noted in the 107 statute, we would then file or speak with the county attorney, file that letter or affidavit, whichever one the county attorney prefers. I've seen it done both ways, both letter and affidavit form. And then just move forward in that regard.
Mr. Chairman,
Please.
and I know every case is different, but in the interim, if it's Title 25, they would basically take possession of that individual. And, but if it's not Title 25, if the county attorney says, I don't want to do that, then what happens to the individual until you all can react? So it's in the evening, the individual's at home, and you have this situation, the county attorney doesn't want to Title 25 it. So what is is that, at that point, do you guys step in and call a judge in the night and say, hey, we need to do something? What happens?
So I'm going to ask you to kind of clarify and take it in two pieces. So if you are able to get them titled, I would assume that would be, depending on vacancies and determination by a community mental health center if they can intervene and do something, or if they would stay at like a emergency room or something. Those might be options if you use the Title 25, but if they're not willing to go down the Title 25, so that was my first one. Then the second one is if they don't use the Title 25, what options do you have?
Mr. Chairman, thank you. I'm understanding that question a little bit more now, and of course, Representative Summers. To answer that, so if we have that gap between the time that we send the affidavit to the county attorney asking for the Title 35, but we have this vulnerable adult who is in a fairly extreme situation. So what we would do is we would try to plug in as many services as we possibly could. We'd try to find some in-home care. We'd try to connect with some family members if possible, a church, any kind of natural safety circle, safety support that this vulnerable adult might have. We would be really diligent in trying to do that casework where we would figure out anything that we could do in order to alleviate such a situation, or at least help it or put some kind of a Band-Aid on it. We would be able to gather up any kind of funding that we could find in order to make these provisions. We would petition the court as soon as possible. We would get with our senior centers. We would try to maybe get some home delivered meals in there. Just really any kind of anything that we could do in order to help this vulnerable adult be as safe as they would allow us to make them.
So how sound or how well established is our system that then allows your folks to do that? I mean, do they know the resources, the other resources, and is that put together well? And frankly, we're trying to understand where the gaps are so that if we can fix them, we can, but we can't fix what we don't know. So that's why we're asking these. And so if the system isn't set up to allow you the ability to reach out within the community, that's important for us to understand.
Mr. Chairman, thank you. One of the things that's crucial in each of our communities is our Adult Protective Services teams. And so those teams, especially if they're well-attended, and they're about 50-50 probably, 50% of them are well-attended and then 50% of them really aren't. But our Adult Protective Services caseworkers are well aware of their communities and exactly what resources they can use to help an adult such as we've been talking about in a situation like that. But using our Adult Protective Services team members, our community members, our senior center director, our chief of police, our EMS people, our hospital administrator, we would just reach out immediately to all of those people and say, hey, what can you do? Our Wyoming Independent Living person maybe is another one. Just these major players in our communities are who we would rely on. And every adult protective services caseworker has good access to those. Does that make sense?
Okay, next slide, please, Katie.
I've got, Mr. Chairman, I got one more question on this. So this is this emergency services that was on that last one, the 72 hours, that's a Title 35. So I guess the question I would ask, and maybe you're going to get to that, is you got a Title 25, you got a Title 35. Are those systems reactive enough to take care of this? Is there tweaks that need to happen, for example, in statute to make sure that everything is covered? And that's the question.
Mr. Chairman, Representative Summers, yes, I think that some of the discussion we've been having through this task force, the reporting, again, this really reinforces why it's important for us to have law enforcement calling us when they've identified somebody, reciprocating that, because the quicker we can mobilize, the easier it's going to be. If we're not waiting until 9 p.m. on a Friday night when we encounter it, it's going to be easier if somebody knew about it at 4 for us to be able to respond. So I do think we're hitting on, through this committee, some of the legislative things that will help with this. But outside of the technical part of the system, and going back to the chairman's questions early on, there really is no system outside of what happens after court gets involved. When Title 35 or Title 25, that's where that system becomes very apparent, and it exists, and there's steps. Up until that point, it really depends on the community. It depends on how many resources there are, the willingness of community members to come and participate in things like the adult protection teams, where then we're always identifying or having the opportunity to identify what is available in a given community. Because when we run into these situations, when we go into a home and it maybe isn't emergent, but we know that this person needs a lot, it really relies on the strength and the ability of that caseworker to move quickly, to access resources, to know who to call. It's really case management. And that's what we offer. And so the system outside of the formal court system is DFS workers understanding, knowing what's available in their community, knowing how to access it, hoping that the partners then are also willing to work with us and move just as quickly as we need them to, have the same sense of urgency, so that then those services can go in. But like with anybody else, they're also taxed, right? So we're relying on the goodwill in a lot of respects of community providers, those local systems, to help us when we engage with someone who either A, does need court involvement, and then those services are mandated and we're doing it, or right before court involvement when we're in the middle of it, trying to do it without court. So that community system, and I think that goes back to the point about adult protective services as a whole does not have any federal mandate. It has no federal system like the child welfare system that then tells the state what it should be doing in order to better serve that population. So we'll skip through this, please, Katie, and go into what's the rest of these are what we've been doing. The rest of these are scenarios. So you can look through the PowerPoint presentation and kind of hear then in this given scenario, for example, scenario number 1, what are the services that are provided to this person? And in the green, it kind of outlines maybe the picture in your head that we're hoping to paint. And then what is it then that are the gaps and the barriers? And that's the question that you all keep asking. What are the gaps and the barriers? And it really is resource heavy. The gaps, the barriers are resources. And I don't know the best way to develop a system, and we deal with this with healthcare, we deal with this in child welfare, where every community has that net of services and resources necessary to help vulnerable adults or those who are at risk of vulnerability stay safe at home or to be somewhere safe if it can't be home. So, Mr. Chairman, I'll look to you whether you'd like us to continue to work through these scenarios as they're on the vulnerability scale, or if you would just like to then consider some of the policy questions that we're back to. What is the role of the state?
Well, I'm looking, and we certainly have talked about the service gaps and the barriers. I think what we at some point have got to do is come back with some recommendations. This task force needs to come back with some recommendations on how we approach the gaps in the different scenarios. Right? In how we're doing that. And so,
You know, Mr. Chairman.
Please.
You know, I guess, you know, the role of the state, that's for us as policy people to decide. But certainly, when you have an adult that is no longer capable, whether for SERV, whether it's Title 35, Title 25, then we have an obligation, I think, because the courts basically tell us we have an obligation. And then I think those other softer services, I think we have to have that. Do we have enough caseworkers in the state to cover these sorts of things? Do we have a little bit of money in the kitty to do those things like housing and perhaps even a dinner to getting the food, right? Finding where the food might be in the community to get the food to the individual. You know, what role do we have in that? And I mean, I think we have a role in all of that. We just, I just don't know to what level, you know, it's like you guys would know, where's the biggest gap that we need to fill, and can we fill it?
well, and Director Schmidt, and then I'll go. I seen you getting ready to push. Any thought? So I think that we're refining this closer and closer to policy decisions, which is what we need to do. But I'm inclined to suggest, Representative Summers, that maybe you and I spend some time now and kind of formulate some possible policy decisions that we should consider. Because I think just saying today in this committee, this is what we need to do, at least what's your idea? And we would be happy to hear from that, but I think to try and refine that in this meeting today is not practical, but I think it's where we need to get. And I would like to work with you and see if we can't start formulating that, and we'll reach out to the agencies and certainly welcome thoughts from members of the task force on suggestions you have, because I think this really is what the task force was created to do, is to come back with recommendations on policies. And I think one of these important components is how to identify and have access to local resources when we know the need's immediate and we can't move fast enough. What are the resources in Cokeville, right? To make sure that this person's still alive tomorrow when it's 30 below. And in that coordination, and I've got some ideas there. So,
Mr. Chairman, I really want to hear from the agencies to get us what they feel is the gaps and solutions for those. And then based upon that, I think that's when I want to make a policy decision, because I want to hear them uninfluenced by my, just uninfluenced by me.
So fair enough, but I would, and we'll hear from them. I think that's right. It's great to hear back ideas from the agencies, but I think that they're also looking at us and say, okay, what do you guys want to have for policy? We can certainly make the decisions much easier once we understand what your policy is and what you define what the role of the state is. And so I think we need to look at those. We've identified the gaps, maybe look at some possible solutions, but then I think we need to chew on that bone and maybe spit out what we think the policy should be, and then that helps them move forward as well. So. Okay. Any other thoughts on this? Nice job. I mean, once again, we don't walk away today with any concrete answers, but I think we've clearly identified in a much clearer way how you are providing the services now, the challenges that you do have, but the options in a much clearer manner. So we'll be back. Okay. Yes, Director Schmidt.
Thank you, Mr. Chairman. And I know you have to work out, which comes first in terms of policy or resources. But I did want to share, I was on the road this last week and visited a couple of offices, and some of our smaller, very small offices, where we have one worker who's handling protective services for children, adult protective services, and juvenile services, all in one person.
So like where?
This was Sundance.
Okay.
Okay. And in Newcastle as well, having that similar situation. And there's 2 points. The first point I've asked is, we have turnover issues. Everyone does, but my question really has been directly to staff is, if you are not here in 3 years, what did we not do to keep you? And it's an unfair question to some of our newer workers because they haven't been in the onslaught of, the grind. But when I've asked that question now in 3 offices, the response has been, I can't do my job because I can't get resources to the people I'm serving. So that issue about resources is very real in terms of, especially in adult protective services, when we're not funded like we are on our child protection side, where we don't have somewhere to put somebody. We really are relying so heavily on that community net of resources in order for us, our caseworkers, to feel like they're being successful. So that's the first question or the first thing that I want to say. But in this world too, where resources are so important, it's also that willingness of everyone to come to the table and have those discussions with us. And that means law enforcement, even though in a lot of places law enforcement doesn't want to have this conversation. That means going to the adult protection teams, because at the end of the day, everybody in this system is going to point at everybody else, because there isn't one entity that is fully responsible for these adults. It doesn't exist in statute, but there's implied responsibility with the Department of Family Services because we provide the case management. And our workers undergo quite a bit of heat in some communities from others who are holding them accountable to the success of that vulnerable adult, when there really isn't a system that our staff can rely on to help them. So it's a long way of saying, I think we need to also reinforce through these conversations that it is everyone that has to rally around these adults. It cannot be the sole responsibility of the Department of Family Resources, one, because we're not resourced, and two, it really does come back down to community responsibility as well. So before we leave that topic, that piece of information that I got last week, I thought was incredibly tremendous as we talk about what is the policy of the state as we look at people who need housing, for example, whether it be temporary or long-term, because they cannot get into a nursing home, but they're vulnerable. They can't continue to live in their trailer anymore. There is no heat. There is no running water. What is the state's role in serving families like that, vulnerable adults like that? So thank you for the editorial comment.
Thank you. Jane, thank you. I'd like to go to public comment. Any public comment on vulnerable adults? Tom?
Chairman Larson and committee, I'm Tom Laycock, AARP Wyoming Associate State Director. I appreciate the conversation you guys are having. This is a conversation that we're having not just here, but I think you're also going to see it in the Labor Health Committee in September. We're getting older. We're trying to figure out sort of what services are out there, where the gaps live. And so I really appreciate you guys are going in this direction. Appreciate what Director Schmidt said in terms of having the needed resources available for her group as well as what's in the community. So just thank you for continuing the conversation. We appreciate that you guys are here.
Mr. Chairman,
Please.
Mr. Laycock, when you say we're getting older, who's the
Not
we?
I'm sorry, I couldn't hear that. Is your mic on?
It's a good response. It's not. You lucked out.
Any other comments? Anybody online, Katie? Okay. We are scheduled for lunch for how long? What time do we come back? 1? Does that work for everybody? Done. Get out of here.